Hey guys, it's Kathy. I hope you're doing well. I'm doing really well. I'm so excited about today. I'm not going to tell you who it is. So if you've seen any of my past streams, you're going to love this one. I'll give you a tiny hint. I'll give you a tiny hint. She sits in my lap while we do the bills. It's a bonding experience. That's what we have for today. That's all I'm going to say. First, we're going to get through Judge Fleischer, and then we're going right into it. I can't wait. I can't wait, guys. All right, let's start with Fleischer. Here we go.
Need a translator? Okay, do you want to bring her up? You are Maria Mireles. Ms. Mireles, you're charged with theft. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, ma'am. You have the right to have an attorney present. If you can't afford one, one will be appointed to you. Please don't say anything, ma'am.
Okay. On August 12, 2023, defendant removed $700 from a cashier and placed it in a small wallet at Foodtown. Complaint stated that the defendant was a former Foodtown employee. Complaint stated he had watched the surveillance video and saw the defendant take the money from the cashier since the new cashier had forgotten to turn in the cashier till and left the money in it. Complainant contacted the defendant and asked if complainant had taken the money. Complainant did not confess to it.
So this is an employee theft then?
It's an employee, a former employee.
Former employee theft, okay. All right, Ms. Mireles, I'm going to find that there's probable cause to go forward with your case. You're no longer employed there, I would imagine, correct?
Correct.
Tell me, are you a United States citizen, ma'am? Okay. I'm not putting any conditions on your bond. Be careful, ma'am. Do not pick up any new cases. Otherwise, I will revoke your bond. I will put you in jail. You will not get any more PR bonds. Do you understand? You have a lawyer. He will help you. You must stay in contact with him. If he comes back to me and tells me he can't get a hold of you because you're playing games, likewise, I will issue a warrant for your arrest. Do you understand? I'll have you go to Victoria. We'll have you sign a receipt. We'll get you out of here, ma'am. Good luck. Thanks.
Judge, you ready for the next one?
Yeah.
Case 4, Castillo.
Aaron White, do you have an arraignment?
Good morning, Judge. I do not. I just have a case that I've signed on since then. And
was it set today for THA?
no, yeah, it was set today for THA. It's Lydia Taft. We've signed on. I emailed on Friday, but I guess it just, we might have done it a little bit too late on Friday.
Okay, so why don't you just get in, email Victoria?
Will do.
New date.
Okay.
You're good. Is she
Thanks,
here
Judge.
now?
What's that?
Is she here now?
No, she's not.
Okay, we got
Okay.
you. Just text or chat with her. Okay.
Will do. Thank you.
Okay.
Judge, there's also a co-defendant. You want that too?
Yeah.
Ventura, page 28.
All right. And so you are Castillo.
Yes, sir.
And then there's one more. There's a Bravo. Do we have a Bravo that checked in as well?
No, that one already just secured.
Just did? Okay.
So Bravo, Your Honor, was the ABI from last week. He was out on bond for DWI and you revoked.
Oh, that's the one. Okay, I remember. All right, you're Lorenzo Castillo.
Yes, sir.
Sir, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. And you are Carlos Ventura. Mr. Ventura, you're also charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You both have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On April 15, 2024 at 5454 Washington Ave, officers were dispatched to an assault in progress, weapons unknown call at Clutch Bar parking lot. Lorenzo Castillo was arguing with an individual in the parking lot he was detained. Officers were able to detain two other co-defendants, Isaac Bravo and Carlos Ventura, based on witness statements. Complainant one stated that the defendant, Lorenzo Castillo, swung at him first and he defended himself. Co-defendants began beating him up at the same time, but was unable to see how many more suspects were actively beating him up. Complainant one stated he did feel pain and was willing to press charges. Complainant one had major injuries on his face and was checked on scene by HFD, but did not want to get transported. Complainant two knows Lorenzo Castillo. Complainant two stated that the defendant and several other suspects were beating on her boyfriend and she was hugging her boyfriend in an attempt to defend him. Complainant two stated that she was also struck by several punches by a defendant and other suspects. Complainant two had blood on her hands and clothes, but she stated the blood was from her boyfriend's injuries. Complainant two pointed out a bump on her head and stated she felt pain. Witness viewed the defendant and co-defendants assaulting complainant one while trying to separate complainant two from the situation. Defendant Castillo and co-defendant Carlos Ventura went and opened the door to the car and continued to assault complainant one. Witness one stated that the defendant is a family friend and he knows the defendant's aunt. Witness two, who stated that the complainant and him were walking towards Clutch Bar and had a verbal argument with the defendant and co-defendants, but was able to de-escalate the situation. Later on the night, as they were leaving the bar, they ran into the defendant and co-defendant, and that's when the verbal altercation, ultimately the assault occurred.
Okay, so there is someone that views Mr. Ventura assaulting.
Yes.
Gentlemen, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as the condition of your bond not to go back to this bar, not to consume alcohol or illegal drugs, and not to have contact with any of the complaining witnesses in this case, and not to be in possession of any weapons. If you guys violate these conditions, I'm going to put you in jail. I will do everything in my power to protect the public from any kind of hoodlums. If that means putting your butt in jail, I'll do it in a heartbeat. Do you understand?
Sir.
If you pick up any new cases, I'm going to light both of you up. I would imagine that probably no contact with any of the co-defendants is probably a good idea as well.
Yes, sir.
You will be monitored by pretrial services. Any violations whatsoever, you will be remanded to custody. No more PR bonds, and I will make your bonds sky high. How old are you? How old are you?
33.
What do you guys do for a living? Okay, both of you will be required to hire lawyers. I'm going to have you go to Victoria. We're going to have you sign a reset. After that, you'll get with Jeremiah for your bond conditions, and after that, you'll be free to go.
He's supposed to be here. I had one already. I hired one.
Who's your lawyer?
Brian Levine. Levine Law Firm.
See that he's filed any documents. Do you see anything else?
I'm having trouble with these. It's not loading through.
So let's do this. I'm going to have you sign the reset, and then we'll just have you take a seat in the juror box, wait for your lawyer to get here. Do you have a lawyer now? We'll give you time. Don't pick up any new cases. You understand?
Yes, sir.
Okay, guys, come on. Castillo.
The jacket is awesome, amazing, spectacular, fantastic.
Rodriguez Garza. Come on up.
Oh, Prez, if if you love the occasional screw up, you're at the right channel. Let me tell you. Hi, Abby.
That's better.
You should know.
Okay, what is your name, sir?
Jose Rodriguez, Carson.
Is it Jose Arturo Rodriguez Garza?
Yes, sir.
All right, sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer will be appointed to represent you, sir. Rodriguez Garza. It's an AFM.
Yes, sir. So this is a DVD case, but I'm going to be seated. On April 14th in Prescott, Texas, officers were dispatched to a family disturbance. Officer met with the complainant. Complainant and defendant are married. Complainant and defendant got into a verbal argument. Defendant grabbed complainant's left wrist, causing pain. Defendant then pushed complainant against the wall and held his forearm against her neck, causing pain as well, Your Honor.
No impeding breath?
No impeding breath, Your Honor. And we haven't made contact with the complainant yet.
You have not.
We have not.
Got it. Okay, Mr. Rodriguez Garza, I'm going to find that there's probable cause to go forward with your case. I'm now ordering you as a condition of your bond not to have any contact with the complaining witness in this case. You may not have contact unless I know she wants to have contact with you. They haven't had a chance to speak to her, so until that point, no contact. I'm also ordering you not to be in possession of any weapons as well. If you violate these conditions, you will go to jail. Number one. Number two, a protective order was issued in this case on the 15th of this month. Get to know it, because if you violate that court order, the state can and will file a violation of the protective order, and that's the capital murder of misdemeanors. You violate these conditions, I can hold you at no bond, and I'll do it in a heartbeat.
Yes, sir.
We will have you go to Victoria. I see that you do have a lawyer. We will get you out of here, but you must stay in contact with Miss Spacey, right?
Yes.
She will tell you if and when you have to come back to court. I will waive your appearance so you don't have to waste your time coming back here. But if she comes back to me and tells me she can't get a hold of you because you're playing games, I will issue a warrant.
Yes, sir.
Don't pick up any new cases. Don't violate the conditions, and stay in contact with your
Yes, sir, I
lawyer.
will.
Page 10, Zelaya.
Page 10. Did you see you say that, right?
Yes.
You got it? Okay. Hi, good morning. Mr. Uceda Zelaya. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Please don't say anything.
So, officers were dispatched to an assault in progress. Officers arrived at Ostianaria restaurant and spoke with a security guard who advised that they kicked the defendant out of the restaurant when it was closing. Defendant was intoxicated. Defendant's friend pushed a security officer, but he did not feel pain. The security guard observed the defendant drive away. Officers located a vehicle matching the license plate and description pulling out of the parking lot. Odor of alcoholic beverage, watery bloodshot eyes, and slurred speech were observed on the defendant. SFSTs were refused, sample was refused, and warrant was obtained.
Look to see if there are any private of the eyes.
I'll take a look right here. You see that?
There's just,
Do you have any traffic infraction? Did you tell me that there was a traffic infraction?
There was not, Your Honor. They were alleging a ABI. The security guard was alleging an ABI. So I can reread it if you want. Officers were dispatched to an assault in progress. They went to the restaurant, spoke with a security guard who advised they kicked the defendant out because the restaurant was closing and the defendant was intoxicated. Defendant's friend pushed the security officer, but he did not feel pain. Security guard observed the defendant drive away. Officers located the vehicle, matching the license plate, pulling out of the parking lot, and that's when they conducted.
What assault are you saying that they were investigating? The one against the security guard?
Yes.
But there was no assault.
Well, it was a class C because there was no pain.
If I may, Your Honor, I believe from the summation, it was that his friend was the one alleged to be the one to push the security guard. So I'm not sure why
Is that
Mr.
right?
Hussein is involved.
Yes. Says Mr. Croker, which is the complainant, told officer that the defendant's friend pushed him, but Mr. Croker did not feel pain.
Oh,
Mr.
so the
Kroger-
friend. So what? Why is there someone chasing after him? Why didn't they go after the friend?
Okay, so when I'm looking at the sworn statement, Your Honor, Officer J. Puente, which is the officer who ultimately pulled him over, observed the suspect's vehicle that matched the description of the vehicle Mr. Crocker described, pull out of the restaurant, I don't know how to pronounce that word, parking lot, and failed to signal lane change. Officer then conducted a traffic stop.
That's something different.
Yeah. I'm trying to figure out
Something
what the
different
right-
because there. My curiosity is was there a traffic infraction to legally stop him?
They're alleging failure to maintain a signal, failure to signal a lane change in their sworn statement here. I'm reading it word for word.
I am a traffic
So then what
infraction.
happens after they pull him over and then
Officer
what?
then conducted a traffic stop
Okay.
at the 11700 block of North Freeway, North Service Road. Officer identified the driver of the vehicle as the defendant. Officer Puente then observed the defendant to have an odor of alcoholic beverage on his breath, watery, bloodshot eyes, slurred speech. Officer detained the defendant.
That's what I was curious about. That's what I was curious about.
Okay, and then he declined everything, so a blood warrant.
Okay. All right. So, Mr. You said I'm going to find that there's probable cause to go forward with you on the DWI. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I will put you in jail. Do you have a valid Texas driver license?
Yes, Your Honor.
Do you have valid liability insurance in your name?
Yes, Your Honor.
You sure? Because if you don't, I'm going to tell you that you may not drive. Aseguranza.
Yes,
En tu nombre.
yes, Your Honor.
Sure.
Yes, Your Honor.
I want you to check before you leave here today, because if not, you may not drive. You can do it later.
He's just saying that you can't legally drive if you don't have a driver's license and you don't have insurance.
I do it. I do it.
In your name.
Yes, Your Honor.
Okay. All right. So no drinking, no drugs. You will be randomly tested. Are you a United States citizen?
No, Your Honor.
Are you in this country with or without permission? Understand, the more cases you pick up, the higher likelihood you have of that permission being revoked. You understand? I don't know if he understands.
Yes, Your Honor. I
Please.
understand. No more problem.
No more issues.
No more issues.
All right. I'll have you go to Victoria. We'll have you sign a reset. After that, you'll get with Jeremiah for your bond conditions. And after that, you'll be free to go. Because you have a lawyer, I will waive your appearance. Would you prefer a translator? Porque tú tienes abogado, no tienes que regresar, pero tienes que mantener contacto con tu abogado. Si ella viene aquí y me dice que no puedes tener contacto contigo porque no estás, te voy a revocar la fianza y te voy a poner en la cárcel. ¿Entiendes, Méndez? Okay. All right. That way.
Thank you, Your
Thank
Honor.
you.
Page 15, Johnson, Susan, come on up.
Susan Johnson, ma'am, you're charged with driving while intoxicated. Second offense, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, ma'am. Okay.
Officer were dispatched to meet the officer call. Trooper on scene advised that they initiated a traffic stop on the defendant's vehicle for speeding 175. Trooper on scene advised officers that they observed defendant to have glassy eyes, slurred speech, odor of alcoholic beverage. Responding officer observed the same signs. Inventory of the vehicle yielded a half-empty bottle of Patron. DIC red, sample refused, warrant obtained. SFSTs were conducted, 6 out of 6 HGN, 6 out of 8 walking turn, 4 out of 4 one leg stand. And Your Honor, the prior DWI was from 2013, because of probation. And she has one dismissed in 2001, but I don't see the reason for dismissal without accounting.
So she has another one that's dismissed as well.
It's dismissed, yes, sir.
Where was that one from?
Centerville?
Can you look to see if there are any more DWIs anywhere else?
No, sir. The only other prior is from 1983. She had some kind of delivery charge. That was a 20-year TDC.
You realize that a third, you're facing 2 to 10 at the penitentiary, right? Ms. Johnson, not only that, but if you have alcohol in the car with an open container, it's a minimum of 5 days in jail pursuant to any sentence that you may get. I'm finding probable cause in your case. I'm ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock. If you're caught driving a vehicle that doesn't have an interlock, you will go to jail. You will not get any more PR bonds. You understand, ma'am?
Yes, sir.
I'll also order you not to consume alcohol or illegal drugs. I'm going to randomly test you. I want to make sure that there's no alcohol, no drugs. If I find that you do, I will put you in jail. If you continue to use alcohol and dope, I will put you in a rehab facility. So I don't know if you have any kind of drug or alcohol issues. If you do, you better address it, because if you don't, I'm going to do it for you. And I promise you, you're not going to like the way that I do it. Do you understand me?
I understand. Your Honor, I was having a medical emergency. When he talks about I had a bottle in my car, it was in my trunk in a.
Ma'am, you have the right to remain silent, exercise the right. Now's not the time to fight your case. Everything you say, he's sitting there typing it down. You'll have a lawyer at some point. This person will go to bat for you. Now's not that time. Tell me, what do you do for a living?
Well, I've been taking care of my husband for the last 5 years.
Do you earn an income from taking care of your husband, like home health care?
Well,
Whatnot?
on widow's benefits.
I'm sorry?
Widow's benefits.
How much money do you? So do you, what kind of income do you have a month?
Widow's benefits.
How much in total do you get a month? You're not answering my question. I don't know why.
$2,400 a month.
Is that the total that you get from every source?
Yes, sir. For rental property.
How many rental properties do you have?
Just one.
Do you have the ability to hire a lawyer?
No.
I'm going to have you fill out an application. I need to know absolutely everything about you. How many cars you own, stocks, bonds, mutual funds, how much money you own at the bank. You must meet the federal poverty guideline to obtain a court-appointed lawyer. So I take it extremely serious. I need to know everything about you, ma'am. For now, we'll give you an application. You will sign a reset with Victoria. After that, you'll get with Jeremiah for your bond conditions. No more alcohol. You understand?
Your Honor, I was not drinking that night. They kept on saying that, but I had sprayed some mouthwash in my mouth. I had sprayed some, and that's why the cop said I had alcohol breath.
No alcohol from now on, okay? Even mouthwash, anything. If you do, and it tests positive, we will assume that you're consuming alcohol, all right?
So they didn't even take a breathalyzer.
Is there a blood test taken?
DIC was read, sample was refused, so a warrant was obtained.
There was a blood sample that was taken from you, so we'll see what
Your Honor, I
happened.
have a double rifle this afternoon, so I have no lymph nodes in my armpits. So the fluid my blood does not circulate, so you cannot get a good reading. I told them to take a reading from my ankle, and they refused.
Reading what reading?
Reading a blood reading from my ankle and my vein. But they took it out of my arms, and I have no circulation.
If you didn't have any circulation, you'd be dead, man. Of course you have circulation.
I have no lymph nodes under my armpits.
But that has nothing to do with your blood. The lymph nodes are there to attack and fight create blood cells to help
It
fight.
doesn't circulate my blood. And I tried to tell them they had to take it out of my ankle. They would not. You should see what
We will see later on, let's see where the evidence comes to, because the evidence is going to point to whose side is correct, either your side or the DA's side and the officers. I don't know. We will not know any of this until we get the evidence. For now, we need you just to fill out the application. If you qualify, we'll have you talk to a lawyer. From no alcohol from now on, though, okay? Please. I didn't even ask, does she have a Texas driver license? Do you see? Thanks, Jim. I totally forgot.
Let me take a look right now, Judge.
Sign for your reset, please.
She's eligible, Your Honor.
All right, Chief 16, Martinez, Megan.
Good morning, Ms. Martinez. Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews. If you cannot afford a lawyer will be appointed to represent you, ma'am.
Traffic stop for a vehicle traveling 70 miles per hour and 45 was conducted and failing to maintain a single lane in close proximity with other vehicles. I also observed watery eyes and slurred speech from the defendant. Defendant admitted to consuming 2 double vodka drinks as well as prescription drugs. SFSTs were conducted 6 out of 6 HGN. 1 leg stand and walk and turn were refused. DIC was read, sample was refused, a warrant was obtained for her blood.
You see if she has any prior DWIs, and does it say what kind of dope she was taking? What kind of pills?
So she has PCSs, but no DWIs, no prior DWIs. With regards to the medications, let me take a look. Okay. Wellbutrin, Abilify, and Adderall.
Okay. Ms. Martinez, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or dope, you will go to jail. Do you have a valid Texas driver license, ma'am? Do you have valid liability insurance in your name? Then you are not allowed to drive, ma'am, and I'm going to have you sign an affidavit promising me you're not going to drive until you have liability insurance in your name. Do you understand? If you violate this court order, crap, and I don't have any. I'm going to have you sign an affidavit. If you drive in violation of this affidavit, I can have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Do you have a lawyer today? Tell me what you're going to do about that. Do you work?
I work like 1 day.
Why?
Contract work and they don't have any work right now.
Why can't you get another job? Yeah. What do you do for the rest of the time?
Housey things.
How much money do you get a month?
I mean, I do periodic jobs that last 2 days or so. I get per diem for that. So that's one, amount. And then like usually if I don't work any jobs, I'll make about, with child support subtracted, I make about $77 a week.
So you live on the child support?
No, I don't get child support. I pay child support.
You pay child support. How much do you pay in child support?
$3 a month.
How are you swinging all this?
Well, I'm behind a little bit, but I pay whatever I can. He said he's $77 and I get $78.
Okay.
That whatever amount he's like $153 taken out if I make a full
All
check.
right. So would you like to apply for an appointed lawyer then, ma'am? Okay. No more alcohol and do not drive until we give you permission. Do you understand? Otherwise, imagine if you don't have anyone to pony up $5,000 to get you out on a bond, you'll be stuck like Chuck in jail. You understand? Okay, ma'am. We'll have you go this way, swear to us that you're not gonna drive. We'll give you the application. You'll sign a receipt with Victoria, and then we'll get you with Jeremiah for your bond. Oh, that's it? Any THAs?
Yes, ma'am.
Okay, come on.
All right, go ahead, Mr. Jeremiah. All right, Judge, you ready?
Yeah.
Page 2, Burnett, Charles, come on up.
Mr. Burnett, do you have a lawyer today?
Yes, sir, but he haven't showed. I
What is it?
hired one, Joseph Landberg.
Okay. Is he's not coming here today? Or he's coming here?
I talked to him Friday, he said he gonna send his assistants.
Okay, so just hang him back and then we'll wait for them to show.
Right this way. Get the sign.
Okay, who's next?
Page 3, Burton, Justine.
Good morning, ma'am. Do you have a lawyer today? Tell me what you're doing about that. I'm sorry? Tell me why you can't afford a lawyer.
I work for, I pay all my bills and the money I make is like, just pay bills on us.
How much money do you make a month?
About 1,800.
Where do all your expenses go? Do
Rent, bills, Wi-Fi, food.
you have any children?
No.
What do you do for a living?
I'm a preschool teacher.
Oh, you're a school teacher? Oh, we love teachers. Absolutely, we'll give you a lawyer. But let me ask you, did you get car insurance?
No, I haven't been driving.
Don't drive unless you have a license and car insurance. Otherwise, it's gonna go sideways real quick. Okay, do you mind giving an application? Deputy Simpson, please. Hi, Day.
4,
Happy
Caraway.
Monday. So I gave her an application. Victoria.
Caraway, page 4.
Mr. Caraway, do you have a lawyer today? Tell me what you're doing about that. How many have you spoken to?
About 3.
That's not enough. And why can't you afford a lawyer? What do you do for a living? What do you do for a living? How much money do you make a month?
1,000.
So tell me why you can't afford a lawyer.
Bills on my son. My son be having doctor visits that cost money. It's a lot.
Perhaps you've not spoken to enough lawyers. There are a gajillion and one lawyers in Harris County. It's a matter of you calling them. It's like buying a car. You don't go to a Ferrari dealership for a lawyer for a car. You go to one that you can afford, like a Honda, and you negotiate with them. Say, okay, I can give you a couple $100 here, and they'll put you on a payment plan. Have you tried that? Really? Who did you talk to?
Can't remember their names, but I know it was a couple that I called, and it was one of my girlfriend, her grandmother had a lawyer, and I talked to him also. So that was about 3.
Are you married?
No, sir.
How many kids you got?
1.
Do you have custody of the child? So do you get support for the child? Where's mom? So you're together with her. Does she work as well? What does she do? What does she do?
I'm not sure. She worked for a company. I don't know.
You're not going to be sure what she does when she works at home and you live with her, huh?
I don't remember the name of the company.
I don't. Well, Caraway, right? Mr. Caraway, I don't believe you. And I want you to start looking for more lawyers because I don't think you qualify. So I want you to start looking real hard. Go on the internet. Get la subasta, whatever you need to do. Start looking, start negotiating. You understand, sir? Please.
Right this way. Page 5, Cato, come on up.
You watch it.
Okay, Mr. Cato, do you have a lawyer today? For sure, absolutely. We'll give you more time. Yeah. If you want to head on over to Victoria, we'll give you another 30 days. Please have a lawyer when you come back, sir. Okay? Please.
Page 8, eBay Richardson.
What page? Levi, do you have a lawyer today? Tell me what you're doing about that.
School right now, and I was also injured.
You're what?
I was so injured and I was in the hospital.
How?
I have a chronic situation with my body. So I have a chronic situation with my body.
Tell me about it.
I had a colostomy bag and I had an infection in my stomach. So I was in the hospital. I had my paperwork from the hospital here. And I was also injured in my shoulder.
What happened? You get shot?
I had got shot on my stomach.
Where? Finally caught up to you.
Huh?
Finally caught up to you. Everything caught up to you. Mr. Richardson, how long have we been dealing with each other?
This has been over since 2015. I've just been having infections in my stomach. That's what happened.
When did you get shot?
2015, and the last time was 2019.
How is if you got shot in 2015, since that time, you've picked up a criminal mischief, theft, felon in possession, interference, assault, PCS, assault, DWI, felon in possession, DWI, felon in possession, terroristic threat, felony assault, and now another gun case. I've never seen this. You've never told me about this at all. In the last 5 years, you and I have been dancing.
But a lot of them, Your Honor, were also dismissed. A lot of them were also dismissed, Your Honor.
How is it that this is the first time we're dealing with this issue now? You tell me about getting shot after all the stuff that you and I've been dancing for the last umpteen years.
But if you actually look at my medical records being in here, I spent a lot of time in the hospital and going through surgeries back to back, being incarcerated, and I have my medical reports right here.
Dave, will you refresh my memory? What happened in Mr. Eby's case
He
again?
had a prior DWI that was dismissed, but he had another DWI in this court that was a conviction in 2023, January 2023. He was charged with felon possession of weapon, and I just emailed Pavel this will be indicted as a felon possession of weapon.
That's what I'm just
waiting for.
I was relying on other people, but I'm gonna have to send that on my own. But I'm in trial tomorrow, so I can't do it.
Where are you in trial? Here with us?
There's one left on the trial docket, Judge.
So since I'm in trial, I'm in a trial prep mode, but I do have a couple.
They hit you with another third degree now because of this. Don't say anything. Just don't. I will give you a lawyer today, Mr. Eby, but it's over and over. It just, you can't expect good things when good things to happen when this behavior persists over and over and over. Deputy Simpson, you might give him an application, please.
A realistic timeline is probably some work in there.
So I would be on the lookout. It's a matter of time before they hit you with a felony warrant, Mr. Eby. So be on the lookout. I'm ordering you now as a condition of your bond not to be in possession of weapons. Do you understand? Correct. You're charged with unlawful carrying of a weapon, but you were a convicted felon. You're not supposed to have a gun. You're not supposed to have any weapons. Do you mind filing those conditions, Dave, please? No weapons.
Yes, sir.
And let me ask you this. Was he also driving at the time with this case?
For discharge, Judge, he was, yes, Judge.
You don't have a license, a Texas driver license, do you?
You gave me my bond condition last time saying no driving. No.
Okay, all right. Don't drive. Above all else in your life, do not drive. All right.
It looks like you signed those conditions, Judge.
Yeah, I see it. I just saw it. Okay. He's good to go with you, Deputy Simpson.
No lies are getting past the judge today. None.
It just clicked when you told me. It just clicked. I don't know why it didn't click earlier. The mics are running slow today.
I was trying to figure out if he's 25 to life, and it looks like he's not. He has one state jail.
How many pen trips he got?
He's got two. Well, no, one.
What if he's-
One's a state jail and one's a
So yeah, he's a 15 to life then.
What are you paying, sir? What are you paying, sir? Yes, sir, no, sir.
Which one?
Yeah, you're fine.
Espinosa, do you have a lawyer today? Tell me what you're doing about that.
Well, I called a couple places, but I don't really got the money for it. I'm not working or nothing.
I'm not.
Well, really, it's transportation, but I've been searching and getting like over the phone interviews and not getting calls back. But I've been trying to get one though.
People aren't going to come to you looking. You're not a king, man. They're not going to come to you to give you work. You got to go look for it. Just because you ain't got a ride doesn't mean that you can't work.
Yeah, I've been calling a lot of people.
Look at this temp. Perhaps you can get work at a temp agency. But how are you surviving now?
My people.
So why do the people of Harris County get to pay for a lawyer for you when you get to play Xbox all day and do nothing?
Play no game.
So what do you do all day?
Try to figure out how to get some money for my daughter.
Man, you got a kid and you're not working.
If I had to sell my game just to pay for diapers and wipes and stuff, I do contribute and
You don't contribute. Hey, man. Get
Pay
real.
for my daughter's thing.
Kids need food, they need clothes, and they need a father. And you're not doing any of those things, Mr. Espinosa. Get a job. Kids need to eat. They don't wait. They need food now. I'm now making it a condition of your bond for you to get a full-time job. If you don't, you're going to be working with me. You understand? It's not going to go well for you, Mr. Espinosa. I want you back here in 2 weeks showing me what you've done to get a job. I want to see applications in, and I want proof, not your word, because I don't take your word. You ain't got proof, things are going to go real bad for you real quick. Do you understand?
Your Honor, if I may. I'd like to move for another bond condition. Received a notice that this defendant was attempting to purchase a firearm while having an active MOAB. It wasn't enough to charge him at the time, but he was attempting to purchase the firearm. And so I want to add no conditions or no contact conditions with any location that sells firearms.
It was because I had pawned it.
Stop. Don't, because you're only going to get yourself in more hot water.
It was the deadline.
Stop. Where did he go to buy this gun? Allegedly.
It's going to take me 30 seconds for me to look.
That's great. You're able to tell that he was trying to get a gun, huh?
We get a flag.
And your money. Your money.
I won't be able to have it today, but if he is returning in 2 weeks, I should be able to tell you by then. I don't have the report number to pull it up, but I can reach out to intake and figure out where it was.
I'm trying to explain that.
Hey, so here's the deal. I'm putting him under bond conditions, no dope, no alcohol.
My only additional condition was any location that sells a firearm so that he doesn't attempt to purchase another firearm.
Let's do this. I'm sending you for a drug test right now. I want to see what's in your system. Let's see why you're not working. You've been smoking dope all day. We'll see. Take your seat for me in the jury box, Mr. Espinosa. Who's next?
Page 14, Jill.
Good morning, Ms. Hill. Do you have a lawyer today? Tell me what you're doing about that. Tell me, what are you doing about that?
I am still looking. I was going to see if I can request more time for that. Please.
What do you do for a living?
I do hair.
Okay. Do you have any children?
Do not.
How much money do you make a month?
Like $1,400. It really just depends on my clientele.
Okay. Can you afford a lawyer?
Yes, sir.
Okay. We'll give you more time. We'll give you another 30 days. Okay. If you have any issues, just come back and let us know. Okay.
Thank you so much.
Please.
More time.
Yes, ma'am.
Page 14, Houston.
Good morning, Miss Houston. Do you have a lawyer today? Tell me what you're doing about that.
This accident because my placenta.
Your placenta's bruised.
Yes, I had.
So I don't want to ask, but you're, okay. It's never good to ask that question because you always get in trouble, you know? So you're not working currently?
So I have like a little money saved up.
No, I don't want to take all your money. Don't worry about it. No, don't. I'll give you a lawyer today, okay? Just, let me see if I have an application on the file. Okay, I need you to fill out an application for me, and then I'll have you speak to a lawyer today. Okay, Deputy Simpson will give you an application. Deputy Simpson, you might give her an application, please.
Ms. Johnson? Case 19, North, come on up.
You are the next contestant on.
Did you say this one?
North, case 19.
All right, Mr. North, do you have a lawyer today? Tell me what you're doing about that. How long you been trying to look for a job?
Since I've been 40 last month.
When's the last time you worked?
I was in school.
In that long?
Yeah.
Why?
I just got out of school, so.
Got out of school where?
TSU.
Did you graduate? Got out of what school?
Texas Southern. I just been in school, so.
So you're in college?
I have a little small business, so I've been looking for clients, but that hasn't been going, so I was trying to book jobs at McDonald's and security for every job you get. So.
How old are you now? You're 30. And so you went to college? And then what happened with college?
Got out like last year.
Let me ask you something. How bad is it now to try to get a job? How bad is it? Does it suck? Is it hard to get a job? You're now charged with theft, Mr. North. How bad do you think it's going to go if you get convicted of this theft? You think it's tough now? Wait.
More judges should say this.
You get a theft conviction on your record. You now have a prior interference that's been dismissed. You now have to stand charged with theft. You will never get a job if you're branded a thief. And you're charged with a lot of money theft. So you think it's hard now? It only gets harder the older you get. It don't get easier. It gets so much more difficult.
All right, yes, sir.
Do you mind giving her an application, please, Mr. Deputy Simpson? Use it wisely. I don't give lawyers to people who continue to pick criminal cases. This is now 2. No more.
Judge, we have an agreement.
Okay.
Page 20.
No. Let's go through the THAs. The dude just got here at 9:45? No.
Go ahead and sign, please. Page 23. 20. That here.
What page?
Page 23.
Quinny. Oh, so, I'm sorry, Quinny. Q. Mr. Quinny, do you have a lawyer today? Take a seat for me in the jury box, sir. Good job. Wonderful. Yeah, please.
Patterson, come on up. Page 20.
Okay. All right, Mr. Patterson, you're charged with criminal trespass and having a deadly weapon. As a result, you're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have a look of bewilderment on you. On April 14th, did then and there unlawfully, with notice that entry was forbidden, intentionally and knowingly enter and remain on the property of another, namely Concepcion Mejia Cruz, without the effective consent, and the defendant carried on or about him a deadly weapon, namely a firearm, while committing said offense. As a result, you're facing now up to a year in jail and or a $4,000 fine. We're going to do probable cause. Please say nothing.
124 apartment complex within Harris County, reference to a suspicious person inside an apartment that the complainant stated that was supposed to be vacant. Found there was observed to have damage on it. Officers made scene, and they found 2 juveniles inside the unit. And as it was cleared, they re-entered and found this now defendant in the bathroom hiding. There was a firearm, a black 9mm Ruger with the serial number defaced and unreadable, scratched off with an unknown instrument that the defendant admitted was his in his possession.
Patterson, I'm going to find that there's probable cause to go forward with your case. How old are you, sir?
21 now.
What do you do for a living?
I really got, I've been fired, but I used to work.
Where do you live now?
With a friend in like Cyprus.
You have any folks around?
Yes, sir. I do. I have my mom and my dad. They live together in Missouri City.
You don't live with them? Why not?
I got put out.
Get back there.
I mean, I could. My mom wants me there, but like my dad, we had got to like a big fight, so it's still kind of like, you know.
So now you're living on the street.
Basically, yes, sir.
That sucks, and it's not going to get any easier, and it's only going to get worse, Mr. Patterson. You have but one life to live. This journey can be wonderful and great, where you do great things and buy great things, or it can be a miserable, rotten existence of life. You're headed toward a rotten existence where you're going to be nothing, and then I'm telling you, Mr. Patterson, you're living your best life now. The older you get, the worse it gets. You become bigger, you become fatter, you get uglier, you lose your hair, and you become more and more unemployable. If you don't do something with your life now, I'm telling you, you're going to end up with a number on your back forever. I see it on a daily basis with the people in jail. If you don't believe me, I can put you there now so you can see. Straighten up. Go apologize to your parents and get your butt into school, because I'm telling you, you now prepare yourself for the next 40 years. And if you don't prepare yourself well, you will end up with nothing. Do you understand? Go back home, get into school, and do something. I'm now ordering you not to go back to the house that you were busted and not to be in possession of weapons. You understand? I'm telling you, you violate these conditions, I will put you in jail. And if you don't have anyone to bond you out, you'll be stuck like Chuck. You understand? Please. I'm going to give you a lawyer today. So I don't want you to pick up any new cases. I don't want you to violate these conditions. Otherwise, I'm telling you, I will keep you with a very high bond. You understand? All right. I'm going to have you go to Victoria, sign a reset, and then I'm going to have you take a seat in the jury box while we get all your conditions and your lawyer. Okay. All right? Speak English, sir.
Yes.
They're not very happy with you, and they want to withdraw from your case. Do you know why? Guess. Why are they unhappy? Porque no están contento contigo. Tu abogado.
I don't know.
Porque no le has pagado.
Yeah, I pay already.
Saying that you pay. Mira.
I pay already.
Te voy a dar 2 semanas. Tienes que poner la cosa en tu auto. Tienes que pagar la fianza para entrar en este programa. Tienes 2 semanas para hacerlo.
Ya tengo la cosa en el carro. You know,
okay, so solamente tienes que...
I made a mistake.
Yeah.
He's paid.
Yeah, paid.
I made a mistake. I was looking at that one and looking at that one.
Right.
That's my fault.
So we're happy?
I have to apologize.
Okay.
So we're happy, Mr. Goins?
Yes, we're happy.
Fantastic. All right, so mira, muy bien. Solamente tienes que pagar el 300 para entrar el programa.
Okay.
Y ya vas a entrar, ¿ok? Te voy a dar 2 semanas para hacer eso. Tienes que hablar con tu abogado y ellos te van a ayudar, ¿ok?
Gracias.
Por favor.
Oh, wow.
I'm glad it ended in a good result.
I'm glad I saw it. I feel bad.
So if, like I said, if Cooper doesn't show at that point, I'll sign your withdrawal.
You knew I'd say so. You knew I'd say so.
My name is Riley Rose.
Hi, Riley. Okay.
Does it go this way?
You're talking about,
Miss Fiona. So she is here and she gave me a certificate that she completed the lab 15 interview and she's attended 3 AA meetings. Did you want to talk to her?
No, we need to send her for a drug test. Make sure she's not using, okay? And then, so what we do is, she is going to go 3 times a week. She's also on probation, 2 years supervisor.
Yes. The 2 hours was completed on Thursday, so it's easier to have it fully.
Yeah. Patterson.
Yeah. She's here today. She just helps with she's also
He's in an apartment, was hiding out in the back of the gun. They had 2 juveniles that first cleared out, came back in, decided to back. They admitted the gun was his and the serial person shaved off. Just found PC. The only thing was no contact with the apartment complex and no weapons. That's it. He has no history.
Carl.
Hello, Judge. I have an Angel Torres. Angel Torres is on the docket today.
Oh, yeah.
This was last week.
I don't see an Angel Torres.
It's Torres, it's Torres. Case number 2504185.
Oh, Torres. Oh, I thought Flores. I see it.
He was on the docket last week. I was assigned to him, and I'm not sure. I guess it was reset till today because he went to get drug tested, and I didn't know. I don't think he made it back in time for while you were still looking.
Okay.
This was last week, and he's on the docket today. He is in court. He's in high school, and I haven't got any discovery yet. So
yeah. Okay. We'll we got you. We'll reset it for you.
Okay. But he's out there in the.
Hold on, Carl. Go ahead, Dave.
Carl, I'm sharing the discovery right now.
Okay. All right, I'll take a look at it.
Okay. You got anyone else?
That's all I had, Judge.
Okay. Have a good day.
You too. Thank you.
Bye. Hey.
Bye-bye.
Hi, Ms. Bates. I am modifying your conditions to allow you to have contact with your wife, but I am ordering you no threatening or harassing contact. What is threatening or harassing doesn't matter what you think. It's how she perceives it. So if I go like this to you, is that threatening or harassing? It most certainly is. Words alone doesn't matter. Conduct in and of itself can violate this. Do you understand? So I don't know what kind of relationship you have, but if you have a relationship where you're constantly butting heads, be very careful because the slightest thing she says can land you in jail. You understand?
I'm a hard working man. I work every day. So, and if
you don't have to say anything. We just don't want anything to happen going forth, and you need to be advised of what you can and can't do, because I don't know what kind of relationship you guys have.
I understand.
But just be careful. Okay.
Appreciate all your help.
Of course, please.
Yes.
Just let me know.
Is he working?
I believe, I don't remember, this is a kid, I don't think so, he watches his aunt's foster kid, or he works sometimes with his aunt at the daycare.
Okay, I guess let's pick a date this week, whatever you want.
Okay, we can bring him in and just be like, hey,
We got to figure something out.
it's popping up quite a bit.
Yeah.
What's the case?
Mr. Johnson,
50.
how's jail? How's jail?
Good.
You know why you're here, right?
Well, I'm kind of confused on some of the details they didn't explain to me.
So you're wanted out of Louisiana for 4 charges of forgery. So anytime you take flight and you're wanted from another state, you get arrested, you come here to court 5. So you're now being held at no bond. And the good news is that because we have so many people from Louisiana, we've got buses coming in and out of Louisiana, every 2 days, every 3-4 days, people come shuffling back. So I don't know how much money you have, but we could get you back to Louisiana quick versus you bonding out. Because if you bond out now, that's money you're gonna have to pony up, and you're gonna have to probably pony up 90 to 100% because you are a fugitive. You are an inherent flight risk. The problem is, though, is that money that you're spending now could be used to hire you a lawyer in Louisiana instead, when if you were to waive, you'd be back home regardless in 2 days anyways. So the state, you asking me for a bond, the state is asking for, you said what, 6,000, right? And due to the fact that you have 4, felony, forgery charges, which is serious, and due to your priors as well, did you say it was in federal probation or? Being, even though it was way back when, it still factors into us because we need to know, if I set you a bond, are you going to go back? Everybody tells me yes. Everybody says it's like little bunnies jumping in the woods. But the reality is that not many people who we give bonds actually go.
Well, in my case, I own my own business, and also, I live here and also in Houston, so I'm actually back and forth, to my son and family and everything.
What do you do for?
I own a fitness company. Pretty trainer fitness company. I'm a well-established businessman, and that's why I was kind of confused about the charges because they say it was on the 21st when they actually the warrant was submitted, but I didn't receive anything or anything, and I'm back and forth.
They're not gonna. You want them to call you and tell you everything? No, they file the charges. They're not gonna apprise you of everything.
Actually, I was, I think when I got arrested, I was going on a trip for one of my friend's birthday, and that's how I actually found out.
So what kind of bond would you make? Around 6,000-ish. Do you think you could make?
I could make that bond.
Well, keep in mind, they're gonna have to do 90% to 100%. It's not the 10%, right? Because it's a fugitive, so I want you to think about that.
All right, so I have to pay how much?
Let's assume you have to
I
pay.
would assume everything because you're, a fugitive.
6,000.
Whatever bond we set, assume you're gonna pay, your family's gonna pay.
What can you make?
I guess 5,000.
Understand that you will never get another chance from us here.
Okay.
We give you 2 weeks from the date of your release to get to Louisiana and turn yourself in.
Okay.
If you do not do that, I'm telling you now, it will never happen again. And this time, if you don't make it up, I will revoke this bond, set it at 0. And I'm going to get you because you can't run forever. And this time I will physically hold you until Louisiana comes and gets you. You understand?
Yes, sir.
The only other thing I want you to understand is that if you were to waive today, you will be probably back to Louisiana within 2 to 3 days without having to shell out $5,000. So
But that's fine. I'll
if you wanted to pay it, that's fine. But
go back into, because that'll give me enough time to take care of my business and find exactly what's going on.
Want me to set the bond?
Yes, sir.
Okay.
Yeah.
I'll do a waiver for all judge.
All right. Good luck to you, Mr. Johnson.
I'm gonna come talk to you in a second. Dave.
You speak English?
Yes.
Great. He's what? Oh, he's a law enforcement officer. Oh, that's why. Okay. You're in public integrity?
Civil rights, I mean.
Civil rights? Got it. Okay. Yeah, we're usually, it's also, what, the other guy? I forget what his name is. All right. Are you Can Goktin?
Yes, I am, Your Honor.
Mr. Goktin, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during questions and interviews with the state detective. If you cannot afford a lawyer will be appointed to represent you, sir.
So this occurred back on May 4th of 2022, Your Honor. Detention officer Jallo Ngotkin physically struggled with an inmate named Hobbs because he refused to stay in his cell after his day room time had expired. Detention officer Jallo's black watch fell off his wrist during the struggle. At that time, inmate Hobbs picked up the watch and as the detention officers walked out of the cell and hid it in his pants. Officer Jala and Ngotkin returned, entered, and searched the cell. At that point in time, Officer Jala leg swept inmate Fobbs to the ground and punched him in the face and torso several times and tried to hold his legs down. Officer Ngotkin then punched inmate Fobbs approximately 20 times in the head and torso area.
Many times.
And then grabbed him by the hair, kneed him in the torso several times, and punched him approximately 13 more times. And elbowed him in the torso twice, and then they both exited the cell.
How bad the injuries are we talking here?
I don't, this is actually a coworker's of mine. She's just out. I remember correctly when I looked at it, I don't think they were severe injuries, obviously, general physical injuries, but nothing super severe.
There, Your Honor, if I may.
Please.
From what I understand, he was taken to the hospital, the infirmary there and released. There were no injuries. So.
How many times to the head is?
That's the first I'm hearing that in the report. I have to dig into it. Your Honor, we're asking for a low bond. He is going to appear in court and fight this case. He's law enforcement. If this case,
where were you? So was this at the Harris County Sheriff's Office or?
This occurred at the Harris County Sheriff's Office. He had since in that time frame had gone and had moved over to Precinct 5 as a deputy.
Okay.
And has been working there for over a year and a half, almost 2 years now, as a deputy, doing a good job, fun job and everything like that. So this is kind of.
So I see that there's a prior one that was disposed of 3 days ago.
So
what does that mean?
For some reason, whenever we take in, even though we bring it in and present it to the grand jury as a misdemeanor, because it involves an officer, I think the clerk's office just automatically puts it in a felony court to determine whether, because official oppression is weird, even though it's a misdemeanor, it's handled up in felony. So then it just has to go through the song and dance of coming back down and assigned to a misdemeanor.
Okay. I just wanted to make sure that there was no prior assault because it, kind of appears that way. So I don't know, this might be a problem because on all assaults that I do, I almost always order no weapons. It's going to be a problem because he's an officer. How are we going to do this?
Ask that he at least be allowed to keep his duty weapon.
What do you think, counsel? Because I'm in 100%, 99% of cases, I think one time ever when I've had an assault, I've let someone have a weapon.
So generally, and I know Josh has been doing this longer than I have, generally I understand when an officer, no matter what department it is, when they get indicted, they're generally put on relief of duty status, which obviously means that they could be called in for an emergency, but are generally sitting at home. And I've dealt with this issue once prior. I personally don't have an issue as long as he's at home. He can have his weapon, but if he were to leave the home, I don't think he should have the weapon, if that makes sense. Which I know.
But what I'm saying is I, for 24 hours a day, 7 days a week, I said no weapons, just no weapons at all. But so are you on administrative duty now? Are you at home? Are you on the field working?
I'm at home, sir.
So they've told you that you're on a paid administrative leave, or how is it?
So since the constable's office is not protected by civil service, I had to resign.
Oh, you had to resign?
Yes, sir.
That sucks.
So
I'm
right
sorry.
now I don't have a job. I don't have anything.
Okay. I'm going to order no weapons for the time being. If something were to change in the interim, come back, we can talk. I'm also going to order you not to have any contact with the complaining witness in this case, but I don't think that that's going to be an issue now. If something were to change, or you get a different type of job, something changes, come back, we can always talk. The only other bond conditions I will put are just don't get in any more trouble. That's it.
Your Honor, we're asking for a $100 bond so he can go through rather than a PR. I know he might be PR bond eligible, but
do you not want a PR bond?
No, we have a bondsman already set up so he can go over there and do a quick walkthrough process.
However you want. I'll give you a PR bond if you want one. I'll set the bond at $100 for you. Okay.
And you have no problem, Your Honor, in doing a walkthrough?
No, of course not. So the only thing I will tell you is that When you do the walkthrough, when you post the bond, you will get a 7-day setting. Okay. Just get in contact with Victoria, our coordinator. That way you don't have to come back in 7 days. You can just email and get a different date. That way you don't have to come back. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with it. It's Mr. Normand, right?
Yes.
You must stay in touch with Mr. Normand. He will tell you if and when you have to come back to court.
Yes, sir.
He comes back and tells me that he can't get a hold of you because you've gone AWOL. I will issue a warrant for your arrest.
Yes, sir.
Don't pick up any new cases. Don't violate these bond conditions. Stay in contact with your lawyer. Good things will happen. Do you have any questions? Okay. Do you mind filing those? Just no contact and no weapons, and then okay.
Is Hope giving you everything yet?
No.
Okay, she's just homesick today. She's pregnant, so I'll get with her, and if worse comes to worse, I'll get it together for you. So
Yeah, no problem. I appreciate it. Thank you very much.
Okay,
Thank you,
guys.
Your Honor.
Thanks. Take care. Yeah, he needs to stay so we can get the reset and get him to sign the bond conditions, and after that, we'll allow you to go with you. Okay?
I would see it in the jury box,
Yeah.
and when they call you up the bond conditions, then you'll be able to go.
Okay. Did you get the cost number? Okay. So bond set. Yeah. Yeah, 100. Jeremiah, can I get a PSR, please, on this gentleman? Yeah. You ready? 2506 262. Okay. Connor, you ready?
I'm approaching an Angel Pena.
Okay.
In custody. I'd spoken with his mom, and I looked at the GPS records that he was violated for. That address is the parking lot of his apartment complex. And the violations were never for more than 10 or 15 minutes. He's told me that's him going to the parking lot or getting something from his car and then going back to his apartment. We talked last week about possibly letting him out today. If that's not a possibility, then we'll have to do something else.
I'll defer.
That happens often when people have the monitors on. They can't leave their home and they put the lines right at the door. I know my niece, she just had an ankle monitor on not too long ago, and her Temu came in, and her Temu was like 2 steps outside the door, and she couldn't get it. She sent me pictures. She's like, look, it's right there. I can't get it. I can't go get my Temu. She had to wait for her son to get home from school.
To the court, I do recall the defendant saying on here that he was going to the parking lot. So that does look consistent, but
Steve, do you mind bringing up Angel Pena, please? Thanks. So family was unable to post it, huh? How many times have we put him in jail? Was this the first time?
So this is my first case with him. You had mentioned there was some history, but this is
No. Yeah, we have a lot of history.
That's
I mean,
the
for
first time.
our case, it's the first time?
Yes.
Okay. I'll give him one more chance. Okay. He's been in jail for now, what, 2 weeks, 3 weeks? It's been at
a
least
little
2
over a
weeks.
week. I think it was not last Friday, but the Friday. 10 days.
Okay. We'll see if that is attention. If not, then I'll revoke it next time and then it'll be a permanent stay. So we'll see if we got his attention. Victor.
He's going. Can I take my second? He's just gonna yell at him first.
Should you want me to just add these or?
Why don't you go to judge and see what the judge wants to bring up? That can just go. I don't need a copy. That's just.
and I'll match.
Mr. Pena, Your Honor.
How's jail? Not good. So the question is, did we get your attention? You say yes. The reality is, did we really get your attention? Because, Mr. Pena, you and I have gone and done this over and over and over. I'm not going to play with you again. Your lawyer has asked me to let you out. You now know your bond is but a meager $5,001. There is no one in this world who is going to make it for you. So anytime you go, unless Harris County is foolish enough to give you a PR bond, which we now are not, you will be stuck in jail if you ever violate. I told him that, Mr. Carter, that this is your first time violating with us on this case here. I'm going to reluctantly let you out. But if you so much as do one thing wrong, I don't give a rat's behind what it is. I'm going to string you up in jail faster than you can even say the word jail. Do you understand? I don't care. When I mean curfew, that means your house. It doesn't mean parking lot. It doesn't mean girlfriend's house. It doesn't mean Grandma Cleopas who lives on the other side of the tracks. It means your house. If you ever violate me again, I'm going to get it to you so hard, your head's going to spin. You understand? No weapons, no dope, and you must be home by 7. Not 7:01, not 7:26. You will never get another chance from me, Mr. Penny. Do you understand? Okay, you shall see. If history is any indication, it's but a mere week and a half to 2 weeks before we will see you again. Prove me wrong. Now, one more question. What are you going to do with yourself when you're out?
I'm gonna try to get a job and finish my online school.
He's going to fight for his right to party.
You need to do something, because when you have too much time on your hands, you become self-destructive. You need to find something to occupy your time, whether it's getting a job or getting into school full time. And I'm now making that also a bond condition for you. You must get a job full time or get into school full time. I'm not going to let you do nothing the whole time and let you destroy yourself. So I want you back here in a week. I'm going to let you out today. I want you back here in a week and show me what you have done to get a job or get into school. If you've done nothing in a week, then look forward to staying with me. You understand? Great. Okay, Mr. Penny. Thanks, Connor.
PR bond or reinstatement?
I don't care. It's one and the same.
Figure out so I know which way to direct them.
Reinstate, that's why it's less work for Jeremiah.
Okay. Thank you, Judge.
Pena.
Step all the way forward. This is Mr. Paget. This is Mr. Venezuela, Your Honor.
Okay, Mr. Paget, good morning, sir. You're wanted out of the state of Georgia for aggravated sodomy and aggravated assault. I'm assuming that's a family violence. Are you waiving formal extradition, sir?
Yes.
Say yes.
Yes, sir.
There we go.
Yes.
And this is Mr. Valenzuela. Mr. Valenzuela, you're wanted out of the state of Nebraska for failure to appear for sentencing, criminal attempt, false imprisonment, first degree, and second degree assault, domestic violence. Are you waiving formal extradition, sir? Okay, we wish you guys the best.
On Paget Judge, he has a second case out of Florida that we need the court to sign the refusal. He's refusing to go to Florida, but he's waiving to go to Georgia. And so there wasn't one that.
And everyone refuses to go to Florida.
Because there isn't a refusal on file. That's why I printed that.
Except the Californians. They're going.
But I printed an extra, but not an extra, I printed a.
Yes, I have that right here. So are you just, I guess we're not gonna do anything because Georgia's gonna come get him?
Yes, and then it's gonna carry over and I'm gonna go ahead and alert Florida to send their governor's warrant to Florida whenever,
To
whenever.
Georgia. Okay, so do you understand what just happened?
Yes, sir.
Basically, we're gonna get you to Georgia. After you're done with your Georgia, everything over there, at that point, Florida is gonna come get you after that. Okay, guys?
Yes, sir, that's what our client wanted. My client. Thank you, Joseph.
Mr. Gutkin, come up. We'll have you sign your conditions now.
Thank you.
Sure.
Caldwell, Your Honor.
Sorry. Good morning, Ms. Caldwell. Ma'am, do you have a lawyer today? How old are you? What do you do for a living? Doing what? Who do you live with? Did you want to apply for an appointed lawyer, ma'am? Okay. Deputy Simpson, I already have one for her. Yeah, I've got one. So we'll just, I already have an affidavit on file. So we're going to have you sign a reset. After that, I'm going to have you take your seat in the jury box while I get it to a lawyer. Okay? Please. Good morning, Mr. Johnson. Mr. Johnson, you were placed on probation for driving while intoxicated. It's come to my attention that you have since violated that probation. Is it true or untrue that you violated your probation?
It's true, sir.
I'm going to find that it's true. I will now revoke your probation and I will send you to 3 days in jail. I will give you credit for the 20 days that you've done. I'm now going to suspend your license for a year, Mr. Johnson. Do not drive, otherwise you will be back in jail. Do you understand? Yes or no?
Yes, sir.
The only other thing I'm going to advise you is that this DWI will go on your record. If you were ever in a car and you smell like alcohol or dope, you're going to be right back over here. From now on, you'll be facing a minimum of 30 days in jail if you ever pick up another DWI. You understand?
Yes, sir.
Good luck to you. So you know you're not here alone. Your lawyer is here with you on Zoom. TVs aren't working, but he's here. You now know that we mean business. This is not a joke. I take this extremely serious. If you violate conditions again, I will triple or quadruple your bond. And at some point, someone is going to stop paying you to get out because they're wasting valuable money. I am now ordering you not to drive at all. Do you understand? You do not have a license. You are not allowed to drive, and I'm going to have you sign with me today an affidavit promising me you're not going to drive. If I find that you drive, I will have a contempt hearing. You'll be facing a minimum of 6 months or a maximum of 6 months in jail and a $500 fine every time you drive because it's an offense in and of itself. Every time you drive. Do you understand? I'm now also, because you cannot be trusted to do stuff on your own, will be putting an ankle monitor on you so I know whether you're consuming alcohol or not. I will pay for it for you so that there's no excuses. If you fail to get this monitor, likewise, I will triple to quadruple your bond. Do you understand, sir? Shoot.
Friday I did the analog exchange, so what about that?
Where is your interlock?
He told me to do it right away.
Your Honor, he had the
Don Lee, tell me.
I'm sorry, can you hear me, Judge?
Yes, we can hear you now.
Okay, I'm sorry. He had the interlock put on he had a vehicle that wasn't operating or wasn't running right, that he didn't put it on the new one. He got a new one that didn't put it on it. He had that put on Friday whenever he got out.
He doesn't have a license. He can't drive though. Donnelly. So he got it on a car, but you can't drive. You ain't got a license.
Oh, his license is suspended. I'm sorry, Judge.
Right. So what we need to do is we need to switch you out to a different device. The interlock on your car is no good because you don't have a license. You can't drive anyways.
I'm working at San Antonio, Your Honor.
You don't have a license. You cannot drive if you don't have a license.
My brother and I, he can come pick me up, but the thing is, I work out there, so if you put an ankle monitor.
You're going to have to get something. I can give you a portable device that you're going to have to take with you everywhere you go. You can either get a portable device at your own expense, or I can give you a scram ankle device and I'll pay for that. You tell me what you want to do.
Device.
Okay.
So I have to work.
Regardless, you can. I'm not limiting your ability to go to work to San Antonio. You can go. The only thing I'm asking you to do is don't drink, don't drive, and you got to get either a portable device or the ankle monitor. The choice is yours. But if you violate the conditions again, there's going to be HE double hockey sticks to pay. You understand? I'm not going to play this game with you.
That spells hell.
So you choose, you tell me how you want to do it.
You're welcome.
I get the portable device, and can I get that removed today? Because
yeah,
I have to go back to work.
Yes, absolutely. Well, that's on you.
They're always trying to extend the appointment. And Friday I had to forcefully tell them like, hey, I have to do this because I've been told to.
Okay. So you can, but don't get in a car and drive it over there. You're going to have to find someone else to drive it. Okay. So we'll get you with Jeremiah.
So I did come with it. So
you're going to have to get somebody to drive it home.
You drove here?
I mean, I had the interlock installed. I just didn't know.
You were not allowed to drive.
Okay, so how can I?
You're going to have to find another way home. You don't have a license. Don't drive, Mr. Delgado. Otherwise, you're going to be doing a ton of jail time.
Okay. Can somebody drive the vehicle for me?
Yes.
While I'm in there? That way they can move it to wherever they have to remove that device?
Correct. I'm okay with you doing that. Just don't drive at all from this point forth. Otherwise, you will be ensuring yourself a lengthy jail sentence. I don't care what the excuse is. All right? Okay. Donnelly, we need to pick a date for you.
Yes, Your Honor.
June 11th through the 13th.
June 11th through the 13th.
Judge.
Okay, it's yours. We will craft an order for you now to remove the interlock from your car, but you must get today the portable device. And then after that, you can go work over there. Just above all else, don't consume anything at least 30 minutes prior to using the device. Because even if it's a false positive, it's on you. Anything that you ate may ferment. Bananas, apples, everything after a while begins to ferment, meaning turns into alcohol. And if it does, and you eat something and it blows positive, it's on you. I would wait after you eat, you consume anything, I would wait at least 30 minutes before you're blowing into the device. And don't use anything that has alcohol in it. Mouthwash, NyQuil, none of this. Don't use any of it. Whatever you put in your body, look at what it is to make sure that it doesn't have alcohol in it. I am now going to make a notation that I've explained all this to you. So if you try to come back to me and try to play me for a fool with NyQuil or with mouthwash, it's not going to fly. You understand, Mr. Delgado? All right, please.
Question, but
I forgot.
Well,
Remove that machine?
that's, yeah, that way.
Johnson Council.
You just tested positive for cocaine again.
Yes.
Okay. Bye-bye now.
That additional paragraph that we had, just take it to here.
Hi, James.
Hey, Judge, I got a new appointment. It was, last name.
Got it. Come up, Mr. Quinney.
Page 23.
Do you have a cell phone number? What is your phone number? 346 288
2432.
Did you get it?
Well, it was 346-288-432. Okay, got it.
This is Mr. Sims. He's been appointed to represent you. We are going to give you a reset. We're going to let you get out of here now. It's your responsibility to get in contact with him today. You must always remain in contact with him. If he comes back to me, tells me he can't get a hold of you because you're playing games, I will revoke your bond. You will not get another PR bond. Do you understand?
Yes, sir.
Okay, and
Give me a second, James. I want to see what all evidence is in real quick.
Okay. I'll be on standby.
Yeah, it'll be 5 minutes. Just Pavel's, it looks like he's enhancing someone.
Yeah, exactly.
Arts and crafts.
Yeah, a little project.
They've given you an offer, a pretrial intervention offer that if you complete an anger management class and 12 hours of community service, they will dismiss your case. The sooner you get this done, the sooner this case goes away and you can stop coming back to court. I will let you and your lawyer talk about it and see if that's something that you want to do. If not, I will set your case for trial. Regardless, we need to know what you want to do. So you guys get out. You don't have to make a decision right now, but I'd like to know at some point here near in the future.
Yes, sir.
You guys talk. He will get in contact with us and let us know. If you do decide to do that, when you do the community service, you can do it like a church, a nonprofit, somewhere where you're not going to get paid. And when you bring the proof, do not bring something on a bar napkin because they're not going to accept it. It has to be on a legitimate letterhead like Houston Food Bank or a church, something like that, that they can actually call to verify. Okay. We will have you sign a reset and then we'll get you out of here momentarily. Okay. He's going to reach out to you because he has your phone number. Also on the reset, his phone number should be on there as well.
And I just sent you some text messages, Mr. Quinney. So make sure you got those.
yes, sir. Thank you.
Okay, who do we have here?
Contreras, Your Honor.
Okay. Good morning, Mr. Contreras. Sir, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. What have you guys worked on?
3 days, time, sir. 3 days to 36 days.
It's 3 days in jail. We'll give you credit for the 36 days that you've done. Mr. Contreras, you must understand that this comes with an affirmative finding of family violence. What that means is that if you ever pick up another one of these cases, you will be facing a 3rd-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. You can also never own a gun or ammunition as a result. You having a gun in your hand is a Class A misdemeanor. You're punished by up to a year in jail. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this, undo this, challenge this. You're stuck with this forever. Is this what you want to do?
Yes, sir.
Well, your other option is to,
Oh, no, I
Yeah.
understand.
is it, so you, this is what you want to do? How do you plead?
No, well, I understand those,
You wanna go to trial, you wanna take the?
I don't want to go to trial.
Okay.
Yeah, I understand that the reason that you're in jail now is your own doing. You failed to come to court at least 5 different times. That's why you're stuck like Chuck. You understand? Had you come to court, you probably could have gotten a good result, but now you know. All right, how do you plead to the offense, sir? Guilty or not guilty? I will find you guilty. I will follow the agreement, sentence you to it. Good luck to you, Mr. Cortez. Thank you, Dan. Yes.
Last name.
On Mr. Olivares, I set his bond at 5,002.
Okay.
I'm going to, between now and tomorrow, figure out a way of getting him into a rehab and which one would be proper for him.
Yes, Your Honor.
Because I don't know if the dual diagnosis, I guess you know what we need to do. Can you do me a favor? Will you set up a TRAS, please, for Mr. Olivares so that we can find out which would be the best facility? And because he's in custody now, I'm going to expedite it to see if we can get it done within the next couple of days. That way we can figure out so he doesn't languish.
I'm gonna call the social worker as well and see what's going on with
And
the
let's-
status.
Yeah, let's regroup tomorrow and see where we.
Okay.
Yeah?
Yes.
Yeah, please, yeah.
On this one, Judge, how much was wrong?
No, it's okay. It's okay. What did I ask you not to do? Not what did I ask you? What did I order you not to do when you got arrested here?
Talking about.
You should, because you signed paperwork to the effect. Think.
Said not to do drugs. Not
Right. There you go. That's using the noggin. You tested positive for dope. What happens when you violate conditions?
I don't know, but I stopped smoking like 3 weeks ago already.
Really? If you lie to me, Mr. Espinosa, I'm gonna light you up.
I'm actively looking for jobs.
That part, I don't believe.
I have. You ask my mama.
Will you reach out to the MAC from Mr. Espinosa? We need to get this gentleman a lawyer because Mr. Espinosa, things are not going well. When did he sign the bond conditions that he was not to use alcohol or any kind of dope? Take a seat for me in the jury box.
Okay.
Mr. Bueno, good morning.
How you doing, sir?
Everything is going great for you. You sound great. You're able to answer our questions. It's great. Do you know why?
because I've been in jail and I've been eating right and doing exercise and watching TV and just taking life one step at a time.
And you're taking the medication.
You're taking my medication and just what I really need daily.
That needs to continue when you get out.
Huh?
That needs to continue when you get out.
Yeah, I'm gonna try. My lawyer said he's gonna try to give me a paperwork with our number with group home. I get a check with my. I would like to go to group home and get my medicine and continue to see a psychiatrist and get myself better, more better.
If you ever have problems, you can come back to us here in court and we can find a social worker to help you.
Okay.
Good things happen when you take the medication. When you stop, it spirals out of control. If you can't find a place to get the medication, come back to us here and we can try to help you. But you
I come ask for help with you.
come back here to court and we will help you try to get a social worker to get some kind of medication for you. You have to continue to take it.
I will try real hard to find go to a place that can help me to get my medication every day.
Get Ricardo's number. You can call Ricardo. He can get a hold of us that we can try to help you.
Okay. Ricardo?
I'm gonna give you my contact info.
Okay.
When you get out, text me.
Yes, sir.
You have to continue to take it.
Sir, I will, sir. I will try to take my medicine.
You now are charged with an assault and failure to identify oneself to a peace officer. You have worked an amazing deal where they're going to dismiss the assault in exchange for your plea on the failure to ID.
Okay.
They're offering you 3 days in jail. We're giving you credit for the 11 that you've done.
Okay.
This will go on your record. It's going to be there forever. From now on, you are facing a minimum of 90 days in jail if you pick up any more cases.
Okay.
So be very careful. Self-control,
Yes, sir. Yes, sir.
right?
Sir,
Self-control.
relax and chill.
That's why you're here,
Yes.
right?
Yes, sir. I use self-control. I need to get my medicine so I can say self-control and control everything and be know what I'm doing. Don't lose it. Stay focused.
If you get upset, walk the other way.
Yeah, I would do that. Now I know what to do.
You're
Thank you.
giving up the right to a trial,
Yeah.
right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. These are your rights that you have to give up to plead guilty.
Yeah, I plead guilty, sir.
Understand, once you plead guilty, you can never undo this. You're stuck with this forever.
Okay.
If you're not a citizen, there's also immigration consequences. They can deport you, exclude you from the country, deny you naturalization, but you're a citizen. You don't have to worry about it.
Yeah, I was born here, sir.
I will take your plea. I will find you guilty. I will sentence you to the agreement. Mr. Bueno, good luck.
Yes, sir. Thank you.
Self-control.
Yes, sir. I will self-control. I will control myself.
Good luck, Mr. Bueno.
Yes, sir. Take care, Judge.
Take care. Have him come up here and we'll get him a social worker.
Yeah, I get a social worker. Like I was lining it up for a social worker. Gets in touch with them. She
Okay, so we've decided what color he's going to wear tomorrow. His jacket. 7% think it's going to be pink. 10% think it's going to be off-white. 13% think it's going to be green. And I don't get to vote, but I would have picked blue. Because, yeah, he wears blue a lot. So blue it is. I'm going with blue. Yeah, Carolyn, I had to get the lollipop in. He waited till the end of the day to break out a lollipop. The best was when, on my Patreon, I have that 2-day trial. And if you want to see it, it's free. You don't have to pay any money or anything, but he's in the middle of a trial. Hi, Monica, and he pulls out a lollipop, and that was just the greatest thing ever. Oh my gosh. Okay, guys, it's time. It's time. It's so time. I don't know if you remember, Judge Frost in Wisconsin. I posted uh the first part of this divorce case, and like they owned a snow removal and lawn care business, and they were getting a divorce, and he moved away, and he's pro se, and she has this lawyer. Now, I'm not gonna lie, this lawyer she annoys me. She just does. She's doing an excellent job, and like she's going far above and beyond. She's nitpicking. She's getting down to the nitty gritty. So just so you know, in this video that I'm about to show, she does get very detailed about assets, which makes it a bit boring sometimes. But don't worry, because he's there and he makes it better. And if you remember in the last video, I gave a hint. He was like, "Yeah, she sits on my lap when we do bills. It's a bonding experience." It was so creepy, and he kept saying it. Hi, HRH. I'm going to watch the wife, because she was so calm and collected during the whole first divorce. I don't know, circus. Well, this time her Wisconsin comes out. Like, the further along we go, the more she sounds like she's from Wisconsin. Her accent comes out more and more. I couldn't play it all today because it was pretty long, so I'm going to do half of it today and then half of it tomorrow. And I don't know. I don't know which is better, today or tomorrow. The judge, guys, this judge deserves something. Like, it's so. Anyway, here we go. I'm going right in.
What your income is or isn't? Yes.
Oh yeah. Judge Fleischer was on, and I was getting him, so I missed the first part. This is right after Judge Fleischer put the lollipop in his mouth, and then I started recording this. But don't worry, we missed a little bit, but don't worry. This lawyer repeats herself over and over and over again, so we'll hear everything.
All right, Your Honor, I would move exhibit number 1.
Mr. Bernardin, I'll let you unmute now. Do you have any objection to exhibit number 1, that financial disclosure?
No, she did say marital bed is now moved into hers, but this marital bed that she's talking about is actually was awarded to me in my last divorce. It's a premarital asset. It's listed on the. So she moved my premarital asset out of my bedroom and then put it into her own bedroom for her own use.
Do y'all
My
remember that?
premarital bed. My premarital bed was over in the apartment before he moved.
Yeah. And now you took my premarital asset and now you're using.
If you want to argue that at the end about what I should do with it, or if I should assign money, I'll absolutely let you. I'll receive exhibit 1 and all of its subparts into evidence.
All right. Yeah. My bedroom set is a premarital asset was all I was talking about.
Okay. All right.
Your Honor, that was by far the biggest document. I do have more, but they are like very, very short. That'll be very brief to get those in.
Okay. All right. Why don't we take a lunch break? Let's come back at about 1:15.
Very good.
Okay. All right. Thank you, everyone.
And so we need to go out and then come back in through the invite at 1:15. Is that right?
You can stay in if you want. I think they're just kicking me out of everything else, not Zoom, but all my other stuff.
Okay.
But if you do get kicked out, then please do log back in.
Thank you.
Thank you all. And we're going to resume testimony with Ms. Bernardin. Whenever you're ready, Attorney Murray.
Thank you, Your Honor. All right, Ms. Brennan. I'm going to go back to an exhibit from Mr. Rodriguez, which was exhibit number 8. So document 134, and I'm specifically looking at page 296 of 302. Do you recall Mr. Rodriguez going over with us what the QuickBooks was showing as of November 11 of 2022, which was that there were these accounts that had $272 or $862 or $671,000, and it was like undeposited funds? You know, do you remember him going over what QuickBooks was showing based on the entries that he could see?
Yes.
And was this sort of inexplicable information on QuickBooks one of the reasons that ultimately we decided to hire someone that was a professional, beyond my understanding, to get to like what is it that was entered or not entered for the business on the QuickBooks account, correct?
Correct.
And so we were never able, or Paul was never able to figure out how these numbers being there, but he could confirm that there were these astronomical amounts that were showing up on QuickBooks based on what was entered, correct?
Correct. Not closing out and things, and yes.
And so you paid, or your mom paid on your behalf, a $20,000 retainer for his services, correct?
Correct.
And so at the time when we're thinking that there's $1 million or $2 million that needs to be figured out, that seemed like a worthwhile investment, fair?
Yes.
But what we learned is it's a bunch of gibberish.
Yes.
All right. And so just as a reminder, we learned that Mr. Bernardin, after not cooperating with our requests informally and formally for discovery, had dumped about 977 files the night before he tendered the computer, correct?
Correct.
Is that the sort of gamesmanship that you had been experiencing from the time you first started asking him for information about the finances of the business?
Yes.
I am going to go through some of the documents that we filed as rebuttals to rebut some of the testimony that Mr. Bernardin offered during the prior days of trial. So I'm going to look at our rebuttal exhibit 25. It's somewhat duplicative, but it also has extra pages. Your Honor, should I open 25, or are you going to pull it through? Or should I open it and then pull it through after we go over it?
April, do you have any preference? I'll need you to pull the rebuttal ones through as they're talked about, but doesn't matter when counsel opens it.
I do not believe it matters.
All right. I think it'll go quicker if I can open it and then she pulls it through when I move on to the next one.
Go right ahead.
Okay. So, Mrs. Bernardin, we talked about the fact that unbeknownst to you, Mr. Bernardin had opened a business in your daughter's name, correct?
Correct.
And so that was actually registered with the Department of Financial Institutions, correct?
Correct.
This is your address and your daughter's name, correct?
Correct.
Did you have anything to do with this?
No.
As a result of do you think it was poor judgment on his part to do this?
Yes.
And are you asking that any insurance policies that are for Charlie be assigned to you as the custodian?
Yes.
All right, and I'm just going to go through. So this is the full 7 pages that's available through DFI. So it shows that this was filed back on 7/13 of 2017, correct?
Yes.
And it was administratively dissolved. Last day to correct was 9/11/2020. So this was not quite 4 years ago, correct?
Correct.
Did you know about this before we started digging into things with the divorce?
No.
And then just proof that we obtained this. All right. Your Honor, I would move for the admission of Exhibit 25.
Mr. Bernardin, any objection?
My only objection is that she did know of it. That was the first step, 6 degrees of separation.
I'll take that as argument later, but not an objection. So I'll receive Exhibit 25.
Mrs. Bernardin, did you own a home before you all moved to Vinburn?
Yes.
And what was the street that it was on?
Fairchild.
I'm opening up Exhibit 26. Did you sell, so was that house listed under your name and Miss Lurvy's name, your mother?
No, it was just solely in my name.
At the time you sold it?
Yep, it was solely my house.
And so you sold that to Himsel's?
Yes.
For approximately $176,500 when there was a loan for $141,200?
Yes.
And that was on or about February in 2017, is that correct?
Correct.
So you were sitting on about $35,000 in profits from the sale of that home?
Yes, that went into the current Vinburn home.
I move for the admission of Exhibit 26.
Any objection, Mr. Bernardin?
No.
Okay, I'll receive 26.
With respect to the $18,000 that check that was bounced, were you left with the impression that that did not need to be paid right now?
Correct.
Your Honor, I would move for the admission of Exhibit number 27.
I don't think I heard anything about what it is.
Oh, the $18,000 was a loan. Shannon.
No, I've heard about that, but I don't know what the exhibit is.
Oh, I'm sorry. Shannon, did you ultimately have an opportunity to talk to Mr. Bernardin's father about the check for $18,000 and the impact it was having on your finances?
Yes. And then this was a text that he had sent.
And so you were left with the impression that the impact of the message was that you did not need to pay that or not pay it, at least at that time.
Correct.
So I can just leave it at her testimony and withdraw the exhibit, Your Honor.
Okay.
So I'll withdraw that one. 28. All right.
Can I just make one mention of the last exhibit that you had about selling the other house? The other house was also a marital asset. So it wasn't, the sale of that house did go into our new house, but I lived at that house and made payments at that house too. Although she originally purchased it and it was in her name.
Your Honor, I move to strike.
Okay, I'm going to consider it an objection, but I'm going to overrule the objection. Again, that's argument, Mr. Bernardin, not testimony. So if you want to testify, I will give you a chance because you went first if you feel like you need to respond to anything Ms. Bernardin said, and you'll get a chance to question her. So you can certainly bring that out and argue that.
Okay.
Ms. Bernardin, about that, when did you start living at Fairchild?
I purchased the home in June 18th of 2010.
2010?
Correct.
And when were you married?
2012, February.
I'm just going to leave that right now. Robin Hood, we already went through. I'm not going to go to that. Exhibit number 30. Is this the website you were able to locate that is associated with the business that Gabe was trying to start while the divorce was pending?
Yes.
Objection.
What's your objection?
Yesterday, Ginger already proved that I started this company back in July. That was before the divorce was pending.
So again, this sounds more to me like an argument about what to believe. I'm not quite following what you're saying, Mr. Bernadette.
Yesterday, that Yahara was created in July. That was before the filing of the divorce. Well, right now, Ginger's trying to say, Attorney Murray is trying to say that Yahara was created during the pendency of the divorce. But that's not true. It was created before the divorce was ever filed. She proved that yesterday.
Well, yesterday was Sunday.
I'll let you argue that later, Mr. Bernadette. That's more of an argument about what to believe or how much weight to give it.
Yeah, I meant before lunch.
Okay.
And so this was information you found on the internet, correct, Shannon?
Correct.
And then you also became aware of mail that was coming in from clients to Yahara Lawn and Snow, is that correct?
Correct.
And this was while the divorce was pending and before you all were allowed to have businesses on your own, correct?
Correct.
And then you also became aware of the fact that there was a bank or some sort of credit going on connected to Yahara Lawn and Snow, correct?
Correct.
I would move for the admission of Exhibit 30.
Any objection, Mr. Bernadette?
Only to the date of the creation of Yahara Lawn and Snow. It was created before the divorce.
And I'll definitely let you argue that factual point, but that exhibit I don't think had any particular date. So I'll receive the exhibit.
Thank you. I'm going to skip Exhibit 31 and 32. I'll withdraw those. We were able to get those in through the financial disclosure statement. Shannon, I'll turn your attention to Exhibit 33. Is this a series of text messages from Mr. Bernadette?
Yes.
And so in it, he is telling you that he has seen that you paid money from your credit card to our office. Is that correct?
Correct.
And this was being offered because Mr. Bernadette previously said he did not have access to your credit card account. Is that correct?
Correct.
And this is just one piece of evidence that shows that he did have the ability to view your credit card account, correct?
Correct.
All right, I'm going to withdraw 34 because we already have the notice of the levy.
Did you want to move 33?
Yes, I'm sorry. I'd like to move 33.
Any objection, Mr. Bernadette?
She's removing 33?
Withdrawing
She
it.
is moving 33 into evidence, removing 34.
Removing it. It's gone. Don't worry about it. Just
So on
ignore it.
33, do you have any objection to that text message chain?
No.
I'll receive Exhibit 33.
All right, now not going to move 34 or 35. We got those in already. Exhibit 36. Shannon, is it accurate to say that before 2024, you had not received any child support payments from Mr. Bernadette?
Correct.
And in anticipation of the hearings, did you obtain documents demonstrating what has been paid in 2024?
Yes.
And so at least as of 4/4, the total amount Mr. Bernardin has contributed to caring for your children is $1,690. Is that correct?
That is the total to date.
You haven't received any payment since then?
No. The last payment was the April 1st.
I would move for the admission of Exhibit 36.
Any objection, Mr. Bernardin?
I mean, yeah, I have no control over that. They automatically took it out of my paycheck every single week. I had nothing to do with it.
Do you object to the admissibility of that document summarizing what they took, though?
Well, we already have the document on file that shows my pay stub. It shows what I've already paid in, and there's a big discrepancy there. I've paid in far more than what she's showing.
Okay. I'm going to, I don't hear that as an objection, so I'm going to receive the exhibit in evidence. Frankly, if you believe another document shows it's understating it, I should let it in so you can point that out to me with comparison to another document. So I'm going to receive that.
Oh, one moment, Your Honor.
Just enjoy the peace and quiet from her.
Shannon, I'm going to ask some of the questions that have to be asked in order for the court to give you the judgment of divorce that you're seeking. So first of all, in order for the court to grant you a judgment of divorce, the court must be convinced that your marriage is irretrievably broken. It's kind of an unusual set of words. So let me ask, first of all, do you feel you understand what irretrievably broken means?
Yes, you explained it.
All right.
Yes.
And do you believe that your marriage to Mr. Bernardin is in fact irretrievably broken?
Yes.
Is there any reasonable chance that the two of you could reconcile your differences?
No, we tried counseling and it didn't work. So.
And with regards to the orders that have already been signed by the judge as it relates to custody and placement, do you continue to believe that those are in the girl's best interest?
Yes.
One of the questions I have to ask, which I'm not sure I prepared you for, is are you pregnant today?
No.
And what was your maiden name?
Lurvy.
How do you spell that?
L-U-R-V as in Victor, E-Y.
Now, the court has the right to give you permission to resume that maiden name should you ever want to do that later. It's understandable that parents may want to keep their married name for as long as children are living with them. And so by asking for the right, you don't have to do it, but now is the time to reserve that so that you wouldn't have to come back to court in the future. So with all that being said, would you like to ask the court to give you that right should you want to do it later?
Yes.
One of the things the court can consider is maintenance, whether or not one spouse should be paying support to the other spouse. In this case, Mr. Bernardin has decided to depart from the business where there was close to $300,000 a year coming in with expenses offset against it. But we've kind of demonstrated that those expenses were actually your household expenses. So instead of a salary, you were just paying for all your business expenses. Do you believe that during the marriage that Mr. Bernardin was more of the breadwinner and the person who was responsible for bringing in more of the income prior to you filing for divorce?
Yes.
How many hours would you say he was working on an average week prior to you filing for divorce?
On Facebook, he would say 80, 90 hours. You know, depends on weather, but a full-time job hours. 60, 80, depends on the season.
And Mr. Bernardin testified that you all had discussed that, in fact, if you wanted, you could be a stay-at-home parent, correct?
Correct.
Did that ever come to fruition?
Things with Gabe never, you had a plan and then a week later, a month later, it changed. So I tried being a stay-at-home parent for 1 week and then I got yelled at that I wasn't doing 50% of my work that I was supposed to be doing, although I had 100% of the housework. So it was talked about. He said I could be a stay-at-home parent.
All right. If Mr. Bernardin was to ask for spousal support from you, would you be objecting to that?
Yes.
Do you believe that he could start another business just as was done with Mad City Snow and Lawn?
Yes.
Do you believe that he continues to have the skills that he could go back to being a manager in a restaurant?
Yes.
You were working.
Objection, Your Honor. Shannon can't attest to my skill set. I tried to go back to restaurants and I don't have the look anymore. I'm a poet. Y'all are gonna know.
Okay. Let me think about that for a second.
Make a poem back to
She
it.
did
Her
work for him?
testimony, not as an expert witness. I don't think she is qualified to opine vocationally what you could do, but I think she can give me an opinion of you used to do this, she knew your skills because she did work for you, and then why she believes that's still possible, but I won't give that any kind of expert weight.
I would need to change my appearance entirely to go back to restaurants.
And I'm happy to let you testify about why you
That's
think
not
that's
true
true.
at all.
Okay, go ahead.
So you were working at Red Lobster when Mr. Bernardin was working as a supervisor at Red Lobster, correct?
Correct, manager, yep.
And it was decided that you would be the person to step away from the job when that became a forced issue, right?
Correct.
Why did he stay instead of you?
He was earning more. His earning potential was more, and it wasn't my career.
Do you recall about how much he was earning back then?
60,000.
How much were you earning at the time from Red Lobster?
You saw between both jobs, I was at 45. So if you take out maybe 25.
Do you have the credentials to go back to being a veterinarian, the tech position that you had?
No, you have to do 2 years continuing education and you have to uphold that. And my license has lapsed. So I would have to go back and to school and do crediting in order to get caught up with the industry.
And so what is your intention as far as work going forward?
To create and start my own lawn company.
Do you believe you have the resources to do that in a way that will be profitable and will allow you to support yourself?
With my family's help, and none of the wasteful spending that he does, yes, absolutely. I'll be profitable.
And are you physically able to work a full 40 hours a week?
Not with the care of the girls that I'm responsible for.
So your point being you'll have to incur the cost of some childcare, but physically you are capable of working 40 hours.
Correct. Yes. Physically, yes, but yes. I was mowing a week after I gave birth to Andy. So.
And in the event Mr. Bernardin asks for any spousal support from you, are you objecting because he continues to have an ability to earn more than you?
Correct.
Understanding that Mr. Bernardin apparently wasn't fired, but agreed to step away from his most recent employer, are you asking the court to hold open maintenance so that in the event Mr. Bernardin has gainful employment, that you can come back and ask the court to consider it at that time?
Yes.
And are you also asking the court to hold it open so that in the event Mr. Bernardin doesn't pay any debts that are assigned to him, that you can come back through the courts, and if a creditor comes after you or you otherwise have to pay for it, you can use the non-dischargeable maintenance claim to get reimbursed from Mr. Bernardin?
Yes.
As it relates to the items that Mr. Bernardin would like to have awarded to him, have you and I, as early as this morning, gone through that list one more time with updates on what you're willing to agree he can have?
Yes.
All right, I'm going to share the screen. And Your Honor, what I would like to say about this is the asset list, or what is often presented as a marital balance sheet, is intended to be not so much an evidentiary exhibit, rather than a demonstrative exhibit that summarizes the things we've gone over, and that would be used in support of a closing position or closing argument. But I guess I would still offer it as an exhibit once I'm done going through it.
Sure, I'm fine with that.
All right, so Shannon, bear with me just for 1 minute. All right, as it relates to the first trailer, you're agreeing that he can have it, correct?
Correct.
And you were able to do some research to look at how much was actually paid for some of these items, and we added that into the comments just to give some reassurances that your numbers were more reliable, correct?
Correct.
So for example, the SureTrack 7x14, you're accepting that it's still worth $2,000 even though you only paid $2,200 for it 3 years ago. Is that correct?
Correct.
As it relates to the next one, you were able to confirm that you originally purchased it for $4,967, but you're willing to accept it at $4,400. Is that correct?
Correct. It drove to Florida and back, so.
All right. And so you accepted his value for the 22 Ferris 800, but you are looking for some sort of compensation or reimbursement for the $309 that you had to put into it, correct?
Correct.
All right. You're accepting.
Or that's on his side.
You want him to have the 22?
Yes.
Sorry. And then your position is that Gabe already took this 21 and he can have the 2020, correct?
Correct.
With regards to the 2019 Ferris 3200 with the bagger, are you saying that he can have it, or are you saying you want it?
That one I will take, but I did have to put the $572.46 in repairs into that already when it came back from Florida.
You accepted his value, but we subtracted that $572.46, correct?
Correct.
All right, for the next several items for the amount,
Can I make an objection?
What's your objection?
This document is 2 years out of date. So I have no ability to have a trailer or own half of these things anymore. It's so far out of date right now that I wouldn't have a place to put these things if I was awarded these things.
I'll certainly
so
let
separating
you.
them now is about 2 years too late.
I'll let you argue that, but again, the explanation was this is essentially a position statement, not a evidentiary exhibit, is not what it's intended for. So I'll let you argue, but I'm taking it as the argument of Miss Bernadette.
and so for the next items listed in lines 10 through 14, you're saying for the amount that Gabe had them listed on his initial document, he can have them, correct?
Correct.
And then this Toro snowblower, or S, there's an S at the end. This is where you had the document that you provided information from someone in the business about what the value would be at this point.
That means there's more than one.
Less the costs that you had to incur to get them into working order. And so for that value, you would like them awarded to you, correct?
Correct.
With regard to the white Ford F-350, which you indicated was your work truck, Gabe had it listed at $48,000. You reported that you looked up the value and the updated amount owed on it so that the equity of that vehicle is $12,385.94, and you would like that vehicle awarded to you and you would accept that equity in your column, correct?
Correct.
The Ford F-350 red, Gabe reported the value at 28 with a debt of approximately 20. You are asking that the 8,000 in equity be assigned to him, correct?
No, the red truck, I mean, I don't know what the loan was at, but he let that truck go. The payments that were made, you shouldn't get any equity in it. He decided that that truck.
Right, but so he's not actually going to get it, but we're asking for that to be assigned to him because he let it go and therefore that would be waste.
Correct. Okay.
Objection. I let nothing go. It has a bad transmission. It needs $9,000 in repair.
Again, Mr. Bernadette, this is argument, and I'll let you argue in response. Absolutely.
And then as it relates to the Chevy, Mr. Bernadette had it reported at 18,000 in value, and you're reporting it at 25,600 based on Kelly Blue Book value. Is that correct?
Correct. Got a salter and a plow with it.
Pardon?
With the salter, the plow, yes.
And we're acknowledging the $9,000 debt against it, but also adding the $1,509.72 that you put into it, correct? Actually, I haven't added that amount in.
No, so 9,000 is what he said owed on it, but that one was paid. The 377 continued to pay from the joint checking account that I was solely putting money in. So the 1,500 was owed to me because he took that truck down there, yet it was coming from the sole money I was earning.
Yeah, we did not put that 1,500 in the equation up here. I can see that. We just have the value minus the debt with the request for it at the bottom.
Okay.
Then you had the Kelly Blue Book value for the white Ford with the at 18,000, 14,000 owed, so 4,000 left. And you're asking for that to be assessed to Mr. Bernadette, correct?
Correct. That's the one I put the 16 in for repairs.
I have it down as $1,164.93 in repairs, correct?
Correct.
And then you'll take the newer go-kart, but you're saying it's not worth $1,400, that it's worth $900, correct?
Correct.
For the 2,800, the 300, and the 300, Gabe can keep the next 3 items, correct?
Correct.
For the Z spray, you would like to keep that at the 7,500, correct?
Correct.
He can have the pergola, and you are asking that he be assessed the $9,500 for the van he gave to Matt, correct?
Correct.
The loan for the van is something that you're accepting personal responsibility for, so that you can also be allowed to have title in that, and you would owe your sister the money that's owed on that van, correct?
Correct. That's something I owe her. So yeah, that's not.
The white van, you would keep that with the value of 800, is that correct?
Correct.
And then this is what I was talking about before, that patio furniture, you could not sell that for 6,800, but since
no, I don't. I'm keeping it for the 68. I'm not arguing that. I'll keep it at the 68.
For the backpack blowers, you're keeping 1, Gabe has 3, so you thought the fair assessment was 300 to 1,200, is that correct?
He already has one. There's only 4 here, but yes.
And then he can have the trimmers and the chainsaws, especially since you already bought new trimmers while he had those in Florida, correct?
Correct.
And then for the push mower, you have 1 and he has 1, and I have that 200 in your column and 300 for his column rather than the 1,000 that he said. Is that correct? How much are the push mowers worth? He said 1,000.
And I thought they were 500 a piece. So yeah, I mean, the one is gone. I don't know which one that is. I don't know the brand or whatever. So I left it at the 500. The one that I have right now is worth $200.
And how much do you think the one that he has is worth?
I don't know which one it is. I don't know what.
All right. Well, we're going to stick with these.
So I mean, 500 max, but you know,
right.
You put the value on it. I'm not, you know.
With the gas cans, there's 12 of them. Are you giving those to him, or is keeping them, or splitting them, or what?
I was fine splitting them at the $250 a piece for the 6 and 6. I wasn't going to argue it.
The hot tub, you said that it was improperly winterized and it has no value. It doesn't work.
Correct.
The party tent for 1,500, he can have it.
Yep.
The forks and skid loader. You said you didn't think it was worth 500. You thought it was worth 300, and that you put that in your column, and you said that it was originally purchased for 500. Is that correct?
Correct.
The bulk salt in the bin, he values at 3,000, and you put that in his column?
Yeah, yes, that's his.
The hedge trimmers, he valued at 450. You put that in his column?
He took them. I had to buy my own.
Yep. And likewise, you said he took the 15 shovels that he valued at $1,000.
What's your objection, sir?
I don't have anything here. So
again, that's argument about the facts, and this is their argument about what they would like me to do. So I'm going to overrule the objection.
And so you just used his value and put it in his column, correct?
He did the split. He split 500 and 500, and I just left it the 500 and 500 split. But he took shovels and rakes. He didn't. He took some. He took his ones already.
Oh, so you're saying that it's 500 and 500?
Yes.
My apologies. I thought you said he took them all.
Oh, no. Sorry. I guess when I wrote it there, I just. And you missed the snowmobiles. He can have them for 3,000.
Yep, that's on there. Thank you.
Yep.
Again, if she's being awarded the house, where am I supposed to put all of these things that she's trying to get rid of?
And again, Mr. Bernardin, that's a great argument that you will get a chance to make. It's not the time for it quite yet, though. I have a follow-up before you move to the next section. On the backpack blowers, are they each, so it's a little inconsistent. It says 5 way off to the left, but to the far right, it says that there's 4, that you have 1 and that he has 3. Are there 5 or 4?
So he already took 1 of the backpack blowers and there's 4 still here on the property.
I get it.
So there was 5 total. So yeah.
So he should have 4 total. You will have 1 total.
So he can get 3 plus he has 1.
Yes.
Okay. I follow now. Now the math adds up.
I typed that up.
Thank you.
Yep. All right, for the real estate, it doesn't really matter what the value.
I don't know what's going on in chat. It's like everybody hates her for some reason. Not the lawyer, the wife. They're saying, chat is saying she's taken all of his stuff. Did you guys not see the first one? Okay, that's fine. That's fine. Don't worry. Don't worry. It gets better.
Or what the debt is, because until it's purchased or complete, it's like you're renting it. So we didn't put any value beyond in the parts that matter. Correct?
Yes. Yes.
And then Gabe said that your ring and jewelry is worth $4,500. You think they were gifts, but you were okay with putting $4,500 on your column.
No, as far as wedding, I mean, I only have my wedding ring. I didn't get like any other jewelry from him. So like, and it's the wedding and we found the receipt for $1,500. So.
All right. So you think the value is $1,500.
And then the rest of the jewelry was gifts from Graham to me. That's not, I mean, yes, they have value, but they're given to me. So they're not.
Given to you by who?
Graham, his grandma.
Oh. Okay.
Had given me and the girls necklaces and different things. But they're gifts to me.
Okay.
And then he has listed watches at $2,200, and you could specifically recall 5 of them?
Yes.
And so you accept his value and put that in his column?
Well, we know he spent
$800
on that watch. He spent that was $500, and then that was just on the Movado. But the Citizen, and he has several of the Citizens, and then he has a Movado, which we're not talking Walmart watches. We're talking $5,000 to $1,000 watches at a piece individually, and he has multiples of them. So
do you want to add $500 to the $2,200 that he had before he bought the last one?
Sure.
I don't objection, Your Honor. How is she just randomly creating numbers out of thin air and watches that don't exist?
Again, Mr. Bernardin, that's an argument about
watches, and I have a Movado that's worth $1,000, and I have a $500.
That's an argument, sir, about what I should believe. So
actually, an
I'll let you make it.
Well, everyone's just going to take her numbers and call them, the Bible, and then.
Sir, you have no idea what I'm going to do. There is no other everyone. It's just me, and you have no idea what I'm going to do. So, please, any objection is okay, but don't argue. Go ahead.
So, Shannon, what you're doing here is you're using the number that Mr. Bernardin put down before he purchased the most recent watch. So we added $500 to get to $2,700, correct?
Correct. The one that Mr. Paul had shown, the $522.23 that watch. So,
and then you're saying whatever.
You have to take off $500 for the broken one. Because the company broke my watch.
I'm going to let you argue, but you got to stop interrupting, or I am going to kick you out of the hearing, and then you won't get to argue. Go ahead.
And so the silver that Gabe said he sold 10,000 to Pop, so I assume his dad, last year for 10,000. Do you remember getting $10,000 from John Bernardin?
So Pop would be his grandpa, not his dad, but He sold some. I don't know. It wasn't all of it. The rest of it, when we were gone and he broke into the house, he took it from the safe. So I don't know how much was left.
All right. And then he's the one who listed the 3 guitars at 3,000. You don't want to fight with him, but you're putting it in his column, correct?
Correct.
The
But
keyboard.
there's
you
only
accept-
2 here.
The keyboard, you accepted his value, but you'd like to keep that for the girls?
Correct.
He listed the televisions at 1,100, but you think at best they're worth 800 and you split it 400, 400. Is that right?
Yes.
For the couches, he listed 3 of them, one being premarital, and he listed a value of 900. I believe you told me one was free, one Gabe's father left, and the other one replaced what you had prior to the marriage, so you think it should be 0.
Correct.
Are you willing, if he wants to come and get one of them, he can have one and you keep the others?
Sure. Yes.
All right. Then we didn't put a value for the table that you said was yours premarital, and we didn't put a value for the table that Gabe says was premarital. You can each take it. The moose table set and the Red Lobster, he assessed at $400. You think it's overpriced, but it's a wash, so you'll keep one, he gets the other. Is that correct?
Correct. Yes, I'll take the moose. He can have the Red Lobster.
All right. And then as it relates to these other things, like they're borrowed, so you didn't, or they were given to him, so he can have them, whatever. We're not putting a listing of value.
They were left, when his dad moved to Florida, he left them here. They're there. Essentially, they're left here, but if he wants them, come get them.
Yeah. Okay.
I'm not going to argue over them. He can have them.
Yep. All right.
Yeah.
So he listed the 22 at 1,200. You said it's worth 300. You said that there was a manufacturer's suggested retail price at 600, but I think you said these were not well taken care of, and that's why you put it at half the value.
Correct. I had somebody look at them, and that's what they would offer. In the condition that they're in, they were kept in a moist basement, and I don't know anything about guns, but they rust when they're not cleaned and properly stored. So that's the value they would give me.
And so these other things that you put in the comments, that was if the gun was new. Is that correct?
The suggested market, or what are they? Market
Manufacturer suggested retail price when it's new. Yeah.
Correct.
And then the 12 gauge shotgun, you said it could be worth 500, whatever. It was a gift.
Correct.
And ammunition, he said that it was worth 700, and that he was proposing you get 600 and you get 100, but you're saying it's worth 600 all day long and you're keeping it all. Is that right?
I'll take it because it goes with the guns, and he doesn't need to have it. Guns or ammunition. So.
And then there was long-term freeze-dried emergency food that you both valued at 2,000, and you're saying at 2,000 he can have it?
He can have it.
Music boxes, 3 of them, $500. He can have them.
He took them already, so.
Okay. Oh, you said that. And then projectors for $700. You said he took the newer one, so you assessed yours at 200 and his at 500. Is that correct?
Correct.
Inflatable movie screen he valued at 700. You said you can have it. The sound system for 1,400. You can have it. Lounge chairs, $60. You can have it. The massage chair you accepted was a gift, and he can have it. Rocking chairs, 3 of them, $200. You can have it. Exercise.
There's only one of the rocking chairs here. The rest of them were in the storage unit or wherever he let Matt have them. So there is only one here. The rest of them went to the storage unit or Matt, or I don't know, but.
Yeah. The freezers. So he said there's 2 freezers and he valued them at 600. You're saying 300 because one of them was free?
One of them was. I said I'd take them for the 600 just because I'm not going to argue, but one of them was free through energy assistance.
So I think because of that, I put it at 300, but you're saying you'll keep it at 600, or what are you saying?
I'm keeping both.
And you're asking for the value to be 300 instead of 6?
Correct.
Because one was
correct.
free?
Yes.
Okay. And And the daybed, you're accepting his value and you want it for 5?
Sure, yes.
The computer, the tent, the security system, the dishes and cookware.
Who's Matt? Well, let me tell you, Fletcher. I'll tell you who Matt is. So, they had some stuff in a storage unit. All right, this is all in the first video. They had some stuff in a storage unit, and Matt is a business owner who owns another lawn care company. And so what happens is their lawn care company and Matt's sort of sell work to each other. Like when they're too busy or whatever, they sell work to each other. So Matt pays him for work he does, and he pays Matt for work that he does. Well, he owed Matt money. He owed Matt a bunch of money. So what he did was he took stuff from the house and he put it in this storage unit. And then he had this van that they owned too. And he just gave the van to Matt. And then he gave him the key to the storage unit. And he said, but whatever you do, don't take these chairs. These chairs are hers and they're like sentimental for her. So she did get her chairs, I believe. I'm pretty sure she got her chairs because Matt called her over to the storage unit, which she didn't know about. And inside that storage unit were jet skis that were for their kids. Well, he gave them to Matt, so that's a contentious point. The whole storage unit and Matt thing was a big deal the last time.
Okay, before we get to dishes and cookware, so the other 3 at his value, he can have them.
Correct.
Dishes and cookware, are you splitting that, and whether it's worth 400 or 4,000?
And the judge is going to stop all this nitpicking soon. We're almost out of it.
It doesn't matter because you're each going to take half, and so it washes it out.
No, so I had a house prior to being married, 3-bedroom, 2-bath. He was married and he lost half of his possessions to his ex-wife. Most of those, the dishes, dining room side. I didn't. I had a full and I cook a lot. So I brought into the marriage more and like a Ninja blender, crock pots, all of that stuff, along with my family getting gifts. So it's not, no, the dishes and that, like I'm keeping because.
So you're not willing to share dishes with him, is that correct?
No.
And what value do you think should be assessed?
It's got 800. I'll take the value if that's gonna, whatever, the 800, that's fine. But most of them were premarital or gifts.
So do you want to put it at 600? Is that what you're telling me? I don't know. Like wedding gifts for both of you or just for?
No, Christmas gifts. The Ninja blender my mom got me for Christmas, crock pot for Christmas. Like I cook and bake a lot. So my family for Christmas, that's what I get from my family.
So if I reduce that to 200, do you think that's a fair value for what you're getting?
Yes.
It's if you had to sell it at a rummage sale or on Marketplace, the things you were talking about before. Where you buy things, that's where you would buy it. So how much do you think you would get if you sold your dishes and cookware at a rummage sale?
$300. I mean, my dishes.
Are you willing to take 600?
Whatever, sure. I mean, to argue over dishes is whatever. It's,
Right. And then
I want the dishes for the value.
He valued the antique phone and pulleys at 300 and the stamping up crafts at 400. Are you willing to accept his values and you get them?
Yes.
He doesn't seem to dispute that the sewing machine was yours. So you'll take that at 0. For $100, he can take the sewing machine table. Is that correct?
Correct.
Signs in the shop, he said, were worth $1,800 and license plates were worth $1,800. You're saying he can have them both. Apparently what?
No, the shop signs I'll take. He's already took the license plates and the money and the cash for it. So those I offset.
Okay. And then what do you want to do with these orange chairs that he said that he gave to Goodwill, but we know that they're at Matt's? It looks like he thought that he purchased them for 70. It looks like Matt's trying to sell them for 100, but I don't think he sold them. What do you want to put in there for the value?
Well, he paid for them. I guess the 70 is fine. It's just that he lied about it. So.
All right. Gabe said that the fake fireplace was premarital and gave it a value of 0. You're fine with that?
Fine.
The collectibles from travels, you're splitting at 300.
Yep.
The magnet collection for 600 you can have. The kids' bunk beds for bunk bed for 600 you'll take.
Yes.
Kids premarital bedroom he can have for 0. The mattress for Gabe's bed was 600 in his column. The mattress for your bed, 300 in his column. And the kids' folding tables and chairs for 100 in his column. Is that correct or no? I wasn't sure because it says gifts from family.
Those were given to the girls, so I don't know why we're divvying up a girl, like a card table for kids. I feel like those should go for the kids. I'll take the value, $100, put it in my column if it's a thing. I just didn't know we were going to divide up the girls' items that were given to the girls specifically. But
are you asking that those be awarded to you without you having to take any value for it?
Correct.
Okay. For the outdoor play, toy, and power wheels, he had those listed at 600. I think you said they were worth 400 and that you were not opposed to 400 being assigned because that is something that you could sell for that kind of value. Is that right?
Yes, the kids use them. So yes, I'll take them for 600 or 400, the 400.
Right. And the kids' clothes, you said for the most part, you get those because of the volunteer work that you do. You get clothes as a credit for that?
Yes, that, or my sister has a daughter that's 12 days older and we share clothes back and forth. So some of it is through her. So.
Okay. And then Gabe said that Andy's bedroom set was worth $1,700 and he was going to award that to you for $1,700. And you said you bought that for $1,700 9 years ago and that you thought a more reasonable value was $400 and asked for that to be assigned to you on behalf of Andy for $400. Is that correct?
Yes.
And the sauna is $500 and he can have it?
Yep.
And there's zoo animals from Gabe's grandma and you agreed the moose was his, but the rest were to be given to the kids. Is that correct?
The rest were given to Charlie.
Yeah.
She picked them out. So those, he can have the moose, but the rest are for Charlie.
At least he got the
And
moose.
the trampoline for $400, he can have it. The trash can.
The trampoline was the girl's birthday money to buy it. So that should go with the girls.
Well, if it's birthday money, that's a gift. All right, stainless steel trash.
Objection, Your Honor.
Stainless steel trash cans.
That was company money.
I'm sorry, what'd you say, Mr. Bernadette?
Company money was used to purchase that trampoline. And company time to transport.
For their birthday?
No, it wasn't a birthday present at all.
Okay,
Well,
well,
I
that
never
was
heard
money.
any testimony from either party about a trampoline, so unless somebody's going to get back into it, I haven't heard anything.
Yeah, that's where we were just at.
Can we focus maybe if there's some like particularly interesting ones to point out? I don't need her to recite to me what the document says on all the rest of these.
Okay, that sounds great. So today we added the debts and just the fertilizer debts. Are you saying that you think the exposure is 15,000 for the people who prepaid for fertilizer that didn't get that service?
Yeah, minimum. Yeah, guessing. Yes.
And are you asking that Gabe would be held responsible for that in as much as anyone, if they're going to be responsible, that would be Gabe's responsibility?
Yes, he billed them. Yes.
And then you said specifically with regard to that levy that if the court orders specific responsibility, and they've already got a hold on your 947.84. Are you asking for the rest to be assigned to Gabe?
Yes.
And then there's another, oh, I'm sorry, it's not a levy, but there's another debt to the Department of Revenue for $8,373. Are you asking that to be assigned to him to help with the equalization payment?
Yes.
And then are you willing to accept that the debt that's owed to Mr. John Bernardin be added because that was money that was available during the marriage? But that that Gabe would be responsible for repaying that?
Yes.
And then per your review, you learned that Gabe used $15,000 on marital credit cards for his attorney when you were using non-marital funds to pay for the attorney. Is that correct?
Yes. At a minimum.
Pardon?
Yes. At a minimum that I found came out of the account directly. But he was also putting them on credit cards and then paying the credit cards off from the Fortify account.
Yes, and we'll talk about that briefly once I get through this document. But so you're also asking that the debt that you owe to your mom for her supporting you while this divorce has been pending would be included. Is that correct?
Yes.
And so you had a very specific number, but that did not include the $20,000 payment that she made to get you to take care of the balance owed to our office prior to the hearing today, correct?
Correct.
You are asking the court to assess an award for the waste based on what Mr. Rodriguez testified to. Is that correct?
Correct.
You are asking the court to order you some of your attorney's fees, perhaps not all, but some. So I don't want to double count. We're not trying to double count, but based on the answers that were denied or not fully responded to, that you had to hire experts and we had to go through days of testimony to bring that information out, as well as just the constant delays and over litigious, like the stalling, the delays in this divorce, correct?
Correct.
Yeah. So Your Honor,
Yeah.
I just want to be clear that this debt to Mary Lurie does include attorney's fees. I haven't put in the number because we're still here today. My intention was to update that, and I can do that as soon as we're done. But we do know, I mean, I can get that at the close of the end of the day and put it in there.
Okay.
All right. So I would offer this exhibit with the request that I can update the attorney's fees. And I don't know if the court's going to want me to put in an affidavit or whatever, but otherwise everything else is plugged in as to what my client thinks the value is and what she's requesting. And I'm going to highlight this because I don't want anybody to think that I'm trying to be sneaky or double count anything. Because this number will include this number.
I understand.
Okay. Yeah.
Okay.
All right. So I will save this now. File save. All right. Stop share. Mrs. Bernardin, about the over litigation and the costs that were incurred, I would draw your attention. Do you remember I sent you an email that showed the different orders I was going to ask you questions about? Do you have that email and or those orders available to you?
Yes.
Okay. All right, let's go back to, you remember when Mr. Bernardin was represented by Cedric?
Yes.
In working with him, we were scheduled for a hearing, but the day before and or the day of, we were able to reach an agreement. Is that a fair statement?
So I filed and then it took him a month before he decided to get an attorney, and then that delayed it farther. And I know we were working things out, but.
Yeah, the court's not going to do anything about the fact that it took him a while to get a lawyer, but we can talk about what happened. So let me pull up the orders so we can kind of follow along. So you filed this on 8/11 of 22, and the first step, actually 2 of them come in like the same day. So on 10/26 of 22, I'm going to pull up document 28.
Yep.
Or maybe I will. Oh, come on, work with me. All right, so we had a hearing before Commissioner Fremgen on or about September 14th of 2022. I was your attorney and Cedric Castellina was Gabe's attorney, correct?
Correct.
And so we entered the stipulation that you guys were going to start communicating by our family wizard, right?
Correct.
And after that, did Gabe continue to post things on Facebook for you and still send you text messages?
Yes.
And we had some specific rules because the 2 of you were still living sort of in the same area, that we had an agreement about what was to be done if somebody was going to use mutual and exclusive time with the kids, right?
Yes.
All right, I'm not going to spend much time on that because we already decided that, but is it fair to say that that got abused?
Yes.
With respect to I'm not going to talk about the one-on-one. All right, paragraph 6. As of 9/14, all future credit card debt will be considered individual debt absent clear evidence of use for marital or business purposes. However, respondent shall be allowed to pay attorney's fees incurred up to the amount petitioner has already paid attorney's fees using joint marital funds. Petitioner will supply respondent with the amount paid for attorney's fees. Once this amount is paid by respondent, both parties shall be responsible for their own attorney's fees. So that got worked out, but Gabe continued to use marital funds to pay the credit card he was using for his attorney's fees, correct?
Correct.
And you did not?
No, correct.
Then it said both parents will obtain a credit report and the social security number for his or her social security number and exchange those. And then it said for each account that she or he set up, the username and password shall be shared and not changed thereafter without an agreement of both parents and disclosure of the new username and password, correct?
Correct.
And so did you do that?
For the passwords that I had, yes. But
and did Gabe do that?
No.
On paragraph 7, parties will only write checks from joint accounts with the agreement on our family wizard for the agreed upon amount. So this had to do with the $18,000 check that happened. We didn't want that to be replayed. So we said, before you write out a check, that has to be agreed upon on our family wizard, correct?
Correct.
And again, both parties will have access to all online bank accounts. Usernames and passwords shall be provided and not changed without a written agreement on our family wizard and with full disclosure of the new username and password. Did Mr. Bernardin continue to write checks?
Yes.
And did Mr. Bernardin start using the credit card?
Yes.
And was that beyond anything that was agreed upon on our family wizard?
Yeah. Yes. There was no agreement.
And we had a specific order that said neither party will pay more than the minimum amount due on credit cards absent a written agreement on our family wizard, correct?
Correct.
And he continued to pay his credit card bills in full from the joint account, correct?
Correct.
And you asked him to stop and he did not, correct?
Correct.
But we did not want to incur the costs of having a contempt hearing because this is when we were in big fights over kid issues, correct?
Correct.
And then this was the paragraph 10 where it said both parties will have the list, you're going to separate them, and then you're each going to have your own client base from those lists, correct?
Correct.
All right. Now, going back on that same day, we had another stipulation and order that was filed, document 31. And in this agreement, it was agreed you were going to stay in the house and Gabe would be in the other property referred to as the apartment, correct?
Correct.
At that time, there was limited room for each of you to access the other person's property, correct?
Correct.
At that time, it was made clear nobody was supposed to be doing surveillance and that the password and username for that system would be provided to you, correct?
Correct.
Did he stop using the surveillance?
No.
Did he give you the username and password?
No, I still can't get in.
And when someone broke into the house, was the disc stolen from the surveillance camera?
Yeah, so I just had a trail cam and they took the memory card from the trail cam.
All right, not spending any time on any kid-related issues. Paragraph 9. As it relates to the business accounts, both parties shall keep the other advised of current usernames and passwords to all joint accounts to our family wizard. Did Mr. Bernardin do that?
No.
It says this requirement involves providing username and passwords for all business accounts, including bank accounts, credit accounts, and client management software accounts. Passwords shall not be changed except by prior joint agreement of the parties. Did that happen?
No, it asked several times.
And did you get it after asking?
At some point we did, but I don't remember how many times it was in, how far it was in. I mean, I was locked out of the office for like 6 months, so.
And then when we did get the passwords, were we able to get in or were we blocked because of the 2-point authentication?
Blocked with the 2-point authentication that they have.
And so this other sub C said business equipment was supposed to be kept available to both businesses. Did that happen?
No.
And he locked or had the lock on items so you couldn't use them, correct?
Correct.
I love it when she's quiet.
There's an order entered on 11/15 of 2022. I won't talk about kid-related stuff. At that time, we came back and got an agreement regarding the business checking. The parties agreed to use the business account to pay. And we specifically listed the house payment, insurance, phone, utility, and vehicles, and nothing else, correct?
Correct.
And yet, Mr. Bernardin continued to use his credit card on that account nonstop.
Correct.
And sub D, that was the non-compete. Nobody was supposed to be taking clients from the other person, correct?
Correct.
Further, nobody was supposed to be applying for credit absent an agreement that was approved by council, correct?
Correct.
And both of you were supposed to open separate accounts by November 1 of 2022, correct?
Correct.
And did Mr. Bernardin, to your knowledge, did he start using his own account?
He opened accounts, but he still used the Mad City. He didn't provide any documents, so I don't know what he ran through them.
But he kept using the money that was going into the account even after he left for Florida, correct?
Correct.
And as far as you could tell, what he was taking it out for was not for business-related purposes.
Objection.
Correct.
I never spent any money out of her account from Florida. Never happened.
Again, that's an argument I'll let you make later.
And again, we came to court with the stipulation that people had to provide credit reports because that still hadn't happened, right?
Yes.
And again, we came to court to ask for the username and password for Intuit and QuickBooks, Robinhood, any account in which Charlie or Andy were listed, Badger Barter, anything in Mad City Lawn, Venmo, PayPal, anything for Mad City Lawn and Snow, any username and password for any other account primarily used for the management and daily operation of Mad City Lawn and Snow. Did you get usernames and passwords for the Venmo accounts ever?
No.
Did you get the username and password for the PayPal accounts ever?
No.
Did you get the username and password anytime before Mr. Bernardin's testimony in this trial?
For which?
Oh, I'm sorry, for the Robinhood account.
No, not before you logged in the other day.
And then was it agreed that there would be a sharing of the business information no later than November 4 of 22, and we listed specifically every contact person and every contract?
Yes.
Did you get that?
No.
And in fact, when we did get the computer, those were the accounts that were deleted, correct?
Correct.
For every request to admit that Mr. Bernardin denied, you and I worked together to find ways to prove that those things were accurate, either through the experts at Digital One Intelligence or Trace Forensics, or through other documents that you were able to find, correct?
Correct.
And are you asking for the court to award you attorney's fees in as much as he agrees that you were put to task to provide things that Mr. Bernardin, had he answered the discovery accurately, you would not have had to spend time or money getting those answers?
Yes.
As it relates to child support, Mr. Bernardin is not working. Child support was based on when he was working part-time at the tire store. Are you asking this court to impute income based on his physical ability to work 40 hours a week?
Yes.
So he quit his job at the tire store? We didn't know that. I think last time he was still working at the tire store part-time. I guess he doesn't work there anymore. And his excuse that he doesn't have the right look to work in a kitchen, well, that's just crazy. Man, people in the kitchen look like people in the kitchen. Oh, man. Okay, so that was today. We got through the lawyer today. There's a little bit of the lawyer left tomorrow, but then it's his turn, guys. Then it's his turn. And it was supposed to be a 2-day trial. Just keep that in mind. But no, they didn't get into kid stuff today, guys, because they already went through a knockdown, drag out trial for the kid stuff. That stuff is all done. So what's left is just the business and the assets. Oh, and they're still married. They're not divorced yet. They're still husband and wife. So we have to get through the divorce as well. But everybody yells at him tomorrow. Everybody. I think people who are just driving by walk in and yell at him a little bit because he just, I mean, the judge tries his hardest. This is a judge that does divorces and child custody and stuff every day. So he knows, he's used to bickering and bickering and bickering. So, you know, he's not going to be like Fleischer, and he's not going to get upset. He's going to try to keep everybody just super focused. And that's what he tries his hardest. He does. The lawyer doesn't help. And I guess that's not her job to help. Her job is to, you know, make him look as bad as possible. And boy, does she ever do that. He met his match with her because she, every time he talks, she slams him down. And the judge tries to help him a little bit because he's not an attorney. So he tries to push him along, but man, but when the wife starts, she was so prim and proper for everything. You know, she just sat there, yes and no. Tomorrow, she gets mad and she starts yelling at him too. It's going to be great. It's going to be great. We got through this part. Wait till tomorrow, guys. I'm going to do the same thing. I'm going to start with Fleischer. That way we get him. And it's a shame because I got some good stuff from that other judge that I just don't have time for. But don't worry, this weekend I'm going to play it this weekend. Oh, Colette, he's so creepy. He's so creepy. All right, guys. Well, thank you so much for coming out to this terribly long stream. I'm going to get ready for courts. Wow, it's late. It's 7:30 here, guys. Courts open at 8. I'm going to go take a nap and miss everything. You watch. You used to be a manager at a restaurant, legal? No, I don't know. I hire him to wash dishes. Thanks for coming out. Who did we miss? We missed Fozzie tonight. We're going to dock his pay, right, guys? We should have Fozzie on to do the next one. And then I will be in the chat. I will take care of the chat. I'll be a moderator with you guys. And we'll have Fozzie do the stream. That's what he gets. Yeah, start drinking extra early because then it'll be just so much better. All right, guys. Have fun at work, school, bed, wherever you're going, whatever you're doing next. I will see you tomorrow. Behave, okay? Love you, Cloud. Bye, guys. Love you, Karen.